Okay, well, I hope everybody had a nice lunch. We are reconvening the California Board of Psychology, and we are going to go to item number 19 on the agenda. Ms. Burns?
Good afternoon, everyone. So currently the Board of Psychology's examination coordinator, Ms. Snyder, is working with the licensing committee to review and update the examination. So for the CAPLE and EAAA, SME qualification, or CAPLE SME qualifications and selection process. A presentation will be made to the board at the May board meeting on the update of this. We also will be having Ms. Snyder making a presentation to the Outreach and Education Committee at their next meeting, and that will be to discuss subject matter expert diversity in the pool of experts and those related issues. So forthcoming updates in future board meetings.
Okay. Any questions from the board? Any public comment? Okay, why don't we move on to number 20? Yes? Yes? Sorry, maybe you couldn't hear me.
I was slow in jumping up after lunch.
I know the feeling.
Dr. Imos from California Department of Corrections and Rehabilitation. I was wondering about the SME situation. My contract was denied. That's why I was wondering just 2 days ago. And I talked to Ms. Snyder about that. And she thought the conflict of interest, I got the government code and read it and responded to each subsection on it. My supervisor went through it and signed it as she asked us to do. But basically, it looks like the conflict of interest for all state employees, because that's what the government code is about, 19990, Title II, is conflict of interest. And so for us who are kind of dealing with this, I was wondering if there's any way you could help us kind of navigate this and know what to do, because if it's all state employees who are being excluded from the SME function of the test construction, I don't know why else I would be looking at the government code. It's really talking about, I assumed, conflict of interest because we get paid and we're also state employees. And that's kind of what it looked like to me. I read each subsection and wrote the memo. But basically, for one thing, I would be willing to do it without pay. So I have no problem with that. I just think that state employees ought to be represented. We're a great big piece of the population. If you look at all the UCs and the state universities and the regional centers and Department of State hospitals and CDCR, we're a lot of people, and we bring to the table real, from each one of these entities, specific viewpoints that would be really helpful for this. And I really, if it's about that, about the money, or about the 2 days we spend, I also said I'll take annual leave vacation, and I don't want the money, just let me participate, because I feel that this knowledge is just as important as other people's knowledge, and of course it's very, very diverse depending on what part of the state you work for. So I was very, very concerned about this, and I'm just kind of asking now for what are the next steps? Help. What can we do? What happens when my colleagues get this? I don't have anything, I don't teach law and ethics, or I don't have a dog in that hunt, so I don't think that would be part of the conflict of interest. It's just the fact of being a state employee. And as I said, I really don't need that money. I just want to offer my services, and I'm sure many of my colleagues would feel this way too.
Dr. Amos, I haven't seen the application. I haven't seen the form.
Mm-hmm.
I'm not entirely sure what portion of the government code there, or the public.
It's Title II, 19990.
Oh, okay. It's
Okay.
not Title II. That's I believe the government code section.
Yes,
Yeah.
and it's conflict of interest,
Mhm.
basically, and personal gain. That's the basic problem of it, is doing this for personal gain. Well, no, not really. I didn't want the money to begin with. Just how can I participate without awaking the impression that I'm trying to do this for personal gain? I didn't even think about it. I was on the test construction committee last year, and now all of a sudden, I'm not appropriate for this year. So
the board can certainly follow up with our office to ask
okay,
questions. I'm not sure if that was the basis for indicating that the board cannot enter into contract with you. I don't know. But the board can certainly follow up with our office if they have a question about it.
okay. Again, according to the way I read the government code, that's all it's about. It doesn't reference any other kinds of conflict of interest except for this personal gain piece.
It might be because of the potential for the state having to pay overtime.
We don't get overtime. Our bargaining unit contract doesn't give us overtime, so maybe that's the problem. I don't know.
Could be.
In any case, pro bono here. Okay. I just feel that, we have a lot to offer, and I'd hate to see all of these people left out of the process because of that. So,
Dr. Emus, I appreciate your enthusiasm to be part of the examination process and the time that you would have taken to do that. And our office will follow up with the Office of Legal Affairs to ensure that we understand what the conflict is or understand if we can address it.
okay, I appreciate that. Thank you.
Thank you, Dr. Phillips. I was going to say, given what was just mentioned in terms of the public comment and given the agendized item, is it possible that, because I feel like to even discuss it's a little awkward because of the agenda item about the presentation, but it seems like that question you're going to research would be important to be a part of the presentation in May in terms of those categories, because I think it would be helpful as a board member to understand that whole process. And I don't know if that was already on slate for the agenda in May, but if we could add that, it would be awesome.
Was, but I definitely was right where you're at. So we should definitely make that a part of it.
Okay, and thank you for bringing that to our attention, Dr. Emos. Agenda item number 20, the legislative update. Ms. Jones? Oh, no, we're going to do that.
Just want to make sure we're almost at the right place. Good afternoon. Just want to turn our attention to item number 20, our legislative update. Ms. Burns is going to kind of walk us through the items. There's some updates to what is in the book. But just in terms of context, I want to thank Mr. Glass-Steagall for his excellent work in helping to prepare for the meeting and prepare me for the meeting. And also hello, Mr. Connor Leitzel, I say it wrong every time. Sorry, Connor. Appreciate all of your research assistance. In terms of contextual, also, we're going to go through the items in the first section that are the board-sponsored legislation, follow up on the items that we've taken a position in the last year, and then there's a list of watch bills, and I appreciate and love the format that it's in. I hope you all find that helpful too, where you can see the actual status of the bill as well as a brief synopsis. However, today is the final deadline for bills to be introduced for the current sessions, correct? So know that we won't go doing a lot of detailed conversation in the watch bills, but if there's questions, we'll go through them. But just wanted to give that as a pathway for the board as we look into this section. And also just want to acknowledge my fellow board members who are on the committee, Dr. Erickson and Dr. Kasuga. We've not had a meeting since our last board meeting, but we also will then have an opportunity to be able to dig into everything that's been submitted before this deadline of today. So I'll turn it over to you, Ms. Burns, to talk about the board-sponsored legislation following up on our item from November.
So last year in 2017, the licensing committee took a look at the professional therapy never includes sex brochure. It's required to be provided to trainees accruing supervised professional experience. And it was decided that this brochure should also go to the Outreach and Education Committee, and that should be reviewed by the Medical Board and Board of Behavioral Sciences along with us. At the March Outreach and Education Committee meeting, the committee decided to have SMEs from the enforcement of our board, and then also the other two boards, Board of Behavioral Sciences and Medical Board, take a look at the brochure and make recommendations. That meeting was held, and it was found that we should do some statutory changes along with the brochure to update the brochure. It hasn't been updated in quite a while, at least substantively. There's a few minor edits that were made in 2011, but it's been a while since the actual content's been looked at. At the November board meeting, you had a draft omnibus legislative proposal, and it was approved at your November board meeting, where staff were directed to work with the Senate Committee on Business Professions and Economic Development, Senate BP and ED, just to make it shorter from now on, for their inclusion in the omnibus bill. And again, the omnibus bill is one bill with many provisions where quite a few different boards and bureaus and DCA entities would be included in one large, big cleanup bill. So in December, our staff submitted the omnibus proposal to Senate BP and ED for inclusion. In January, the committee informed us that they would not be accepting our proposal as part of their omnibus proposal, but that they offered their assistance in finding an author in the Senate or Assembly in order to carry the bill. Currently, we have started working with Assemblymember Levine for a spot bill to be introduced, since the deadline is today, since the language is still in transition and we're still working on that language. So there is currently some attachments that we've provided. Attachment A is the recommended changes, additional changes to the code sections. That includes on page 2 of 3 of attachment A, that sexual behavior, this definition does not include the provision of appropriate therapeutic interventions relating to sexual issues. This also added on page 3 of that document, sexual behavior to sexual contact in the determination of sexual misconduct when we're using discipline. Attachment B is a chart for your guys' use or information. It includes the business and professions code sections along with the penal code sections, the APA ethical principles, and then our provisions of the, well, at that time it was the omnibus proposal. And so you can look through that to see kind of where things match up versus where they don't. And then the last but not least is attachment C. And these are the examples of inappropriate sexual behavior that the board staff have found in closed cases that the board has seen over time, where these behaviors didn't meet the definition of sexual contact.
And Ms. Burns, if I might interrupt you slightly, attachment C was a hand carry on your
Yes.
table this morning.
Apologies. So does everyone have the paper version of that one? Okay. And so we've gone ahead and separated these out a little so you can see inappropriate contact that doesn't meet the statutory definition, consensual and appropriate communications, and then some of the grooming behaviors that have led to sexual contact in these closed cases we reviewed.
Sure, Ms. Orrick.
Really quickly, just to add and to just make sure the board understands that the language for Business and Professions Code sections 337 as well as 728, the underline and cross out language was the approved language from the November meeting, and the language that is highlighted in 728 and 2960.1 were refinements that staff and legal counsel came up with and is proposing to the board today. So I just wanted to add that.
And it would also be important to note that the revisions, the initial revisions at your November board meeting were also reviewed by Board of Behavioral Sciences and the Medical Board. They were on board with those along with the draft items. I can't remember the number right now, but the actual revisions to the actual brochure that are in your board packet as well.
And so where we are at this point in time, we and thank you, Ms. Monterrubio, for joining Ms. Burns at the table. Is you want us, the request is to adopt the attached language and delegate staff to work with the prospective author, who we now know is Assemblymember Levine. Also, after we handle this item, just as a preview, we're going to go back to item number 15, which is referencing what Ms. Burns just mentioned about the feedback from other boards. But is there any board comment? Yes, Dr. Horn.
After this is exactly the right place. So I have a couple questions. First of all, does the brochure accompany this bill, or is that just something we're doing separately?
The revisions in the statute, some of them are necessary in order to change the brochure. 'Cause
Okay.
currently, the statutory provisions in 728, I believe it is, tell you what has to be included in the brochure. Sorry, 337. So some of the revisions are necessary for the brochure. Some are necessary for the recent changes that the three boards wanted to make in the brochure as well. So I guess it's a twofold. So like getting rid of the reference to an abolished agency within Department of Justice, or the AG's office, the sexual assault program of the Office of Criminal Justice Planning, which was abolished in 2005. Removing that language would also need to be taken out of the statute, since it says we shall include those items.
Okay.
So.
And so I have a question about the actual language, but I want to ask a question about the process. Why wasn't this accepted as part of the omnibus?
The committee always gets the choice of whether or not to accept something. Omnibus provisions are usually cleanup bills, things that are non-controversial, bigger substantive discussions or bills. Usually they want to give the committee the full breadth of the bill. They want to have a longer discussion. It follows like a less expeditious process, I want to say, because the omnibus usually is pretty late. It's a lot of technical provisions and changes. It's usually, like we found out last year when we didn't get the bill number till pretty late in the process, it's kind of a shorter, faster version because it's usually less substantive changes. So I think in our conversations with them, there were concerns that this would be a little more substantial. So
It would be substantial and not.
it's not as much like our cleanup provisions on who pays the psych assistant fee change and a delinquency fee to make it modernized to what other DCA entities have. So it's not that it's just moving an and or a comma, but it's also that it probably deserves a bigger policy discussion.
Okay. Then I have a couple of things about the. Yeah, go ahead.
I just want to clarify one thing. They now refer to the omnibus bill as a sunset cleanup bill. So it really makes it clear that what they're trying to clean up is prior changes to the Practice Act that were taking place as part of the sunset review. So this really wouldn't fall within that category.
And it's up to
Does not fall into.
no.
Mm-mm.
In previous years, you'd see quite a few provisions in the omnibus if they weren't too substantive or controversial, and you'd just pile them all into one large bill. But it sounds like that's the movement. It's to do sunset cleanup is the omnibus purpose.
Okay. So I have a couple things that I want to say. Under C1, why is licensed educational psychologist capitalized and none of the others of us are? I don't think it should be capitalized.
2 of 3.
117 of the large thing.
Oh,
So it's in attachment A under 728 C1. Psychotherapist
Yes.
means.
I'm not sure.
So that would be a change or a recommendation I'd make. Another is under number 3, sexual behavior. Inappropriate contact or communication. I think we would also want to say inappropriate or unwanted. I think we want to make that a little broader.
I would question, do you mean it has to be unwanted as if sexual harassment type, or so in those cases where the
I said it's or, it's not and.
or okay,
Inappropriate or unwanted.
gotcha.
That's my recommendation. I mean, I think we have to think of that piece as well.
You think unwanted is better than unwelcome? Could be better.
I don't know. Unwanted is how I would think of it, as opposed to unwelcome.
For some reason, unwelcome comes to mind. I don't know from where, but let's go with unwanted if that sounds better.
I'm okay. I mean, if y'all decide something else, but I'm just saying that sentiment needs to be there.
Yeah.
Is partly what I'm saying. And then this definition does not include the provision of appropriate therapeutic interventions relating to sexual issues. I agree with that, and I remember that we talked about that. To have that, I don't know, there's something about the wording of it or where the wording is that just is a little, I don't know if it should say note, colon, this definition, or something like that. I mean, to have it, it just reads weird to me, but it may be because it's language I'm not familiar with. And then any act of sexual behavior or sexual contact. Okay, so I'm all right. Those would be my.
What was the any act of?
Nothing. I was just reading it and saying it out loud, and went back to the definition to make sure. So these are very minor changes in what's already there.
Gotcha.
Right? I mean, no, I'm asking.
Oh,
To what's
you're saying?
to the existing law, these are minor changes, but we're clarifying what we mean.
I think adding a new definition or a new behaviors, I don't know if you'd consider it
Yeah, but what I'm saying is the bulk of this language here
is existing.
is already there. Okay. And we are just making it more modern and more current and more appropriate.
Definitely trying to capture the issues that the board is seeing in its enforcement related materials that are, the current definitions don't capture modern modes of communication. They don't capture current sexual exploitation that is, I think, widely accepted as sexual exploitation and grooming behaviors, and that this would kind of help modernize that.
And you know, I was going to say, Ms. Monterubio, if you wanted to add anything too, and I'm almost thinking, Dr. Phillips, that some of this conversation does involve going back to number 15 to kind of look at the brochure to kind of inform this. So I don't know if everyone's feeling that way, because I feel like they kind of, they do go together, which is why we did the remove around. But I think to your question and to your point, the review of that might also inform our thinking about adopting language. Does everyone agree with that? You know, because I think your question about why would we even be changing it and looking at kind of how we communicate it is one and the same. Am I making sense? Well, I think because of the comment that was just made about Ms. Burns saying that the fact that the board is seeing different issues in enforcement, and if we're going to adopt a language to move something forward, to have that fuller discussion about enforcement's responses to what we're receiving as complaints, does that happen before a question about adopting language happens, or does it happen afterwards?
To my mind, I mean, it's fine with if this gives us permission to put something in the brochure, that's fine with me. But I want it to be as inclusive as we'd want it to be and specify in the brochure.
And I guess
Fine with me.
And I guess why I'm saying that is because I think the feedback that we received from the medical board and from BBS, I think answers part of your question, Dr. Horn, of like, why would we be looking at this now? I think that feedback that was received, as you mentioned in your lead up in terms of even presenting the draft language, I want to make sure you have an opportunity to share why would we even be wanting to present this to an author. And I know we had lots of discussion about it last month, but some of what you just gave in the preface gets covered from item number 15. Am I correct? You know, but
I mean, it informs your discussion for statutory language. I mean, to see what we're talking about in general.
But maybe we can go forward without that. But I just feel like if we need to reference that, and I don't know if you wanted to add any contextual information to Dr. Horn's question as to the modernizing it, what you're seeing in enforcement cases and complaints.
Well, I think most of you have seen cases that you've been asked to obviously vote on, and you're seeing sexting, kissing of a patient, which isn't included in sexual contact, Oh, I'm sorry. So you've seen cases where there's been sexting, selfies. So things are changing, and you're seeing cases that are including that type of what I consider grooming behavior that is not considered sexual contact.
Right.
And that's specifically defined in section 729, item number 3. Sexual contact means sexual intercourse or the touching of an intimate part of a patient for the purpose of sexual arousal, gratification, or abuse. And that doesn't include kissing,
Right.
but we've seen that in cases. So I think looking at the brochure and meeting with the other two boards, we felt that there was a need to make some changes.
I don't disagree with that at all, and I do understand that. So I mean, maybe, and if the rest of the board does, I totally understand that. I'm not questioning that. My original question was, why didn't this get approved and as part of an omnibus bill? And what I heard you say was that it's a more complex thing. And that's why they recommended that we separately include, separately do this as a bill rather than wrap it up, because they felt it was a more complex change we were making, or more substantive.
It's really not like the technical changes you normally see in an omnibus bill. And they always have that opportunity. So it's not like the technical, technical changes we are normally making in an omnibus bill, which are generally sunset cleanup or other cleanup provisions, old outdated codes, those kind of things.
So would be for me, if you're gonna present something like this, because of course, when I left it at the last meeting, these things were going to go on. It was going to be part of this omnibus bill. Then it comes to us, and it's like, well, we've done all this, and now we're going after a bill. And there was no reason. You gave no reason in your memo about why we were turned down to be in the omnibus bill. It wasn't. You gave no reason for it. So I'm like, well, wait a minute. Why did we get turned down? And is this something we really want to pursue?
I don't think
separately?
they're trying to say that it's not a good thing to pursue, because what we've gotten feedback from
No, that's not what I'm saying.
Oh.
I'm telling you my reaction.
Oh.
It was like, well, why did this get turned down? And, so is this really something we should be bringing up? I mean, there's no reason why we got turned down. So I'm like totally questioning, what's all this about? Why are we going forward with something? We got turned down. What's that about,
You'd like that in the memo, so it's
yes,
a little more
let us
covered.
know. Here's the reason it was turned down. They thought this wasn't just the kind of little technical thing that usually is, that they usually include. This is a bigger issue or a bigger deal, and so that's why they turned it down and suggested we go for a bill.
Okay, Dr. Hart, I'm going to see if any other board members want to get in on the
Okay.
conversation. And I think that more importantly, from my understanding on this, is that we approve this language not only in the eye of it being approved as omnibus legislation,
Right.
but we thought these issues were important.
Right.
And I think that appreciate those additional pieces of feedback in terms of the unwelcome language or unwanted language. And I don't know if you wanted to jump in at this point, Dr. Erickson, because I think you had some thoughts about unwelcome versus unwanted. But I think that I noted on that, and I hope everyone is clear on the distinction between omnibus legislation, which is now referred to as sunset review cleanup, as Dr. Phillips reminded us, and then you all were able to secure a legislative sponsor of this bill for what the board approved and has been looking at over the last couple meetings. So does anyone else have questions or have any reaction to the language or the process or any other concerns from Ms. Burns or Ms. Monterrubio? And that's why she's also here at the podium to be able to address any of the enforcement issues. Mr. Fu.
Out of curiosity, Ms. Burns, are the Medical Board of California and the Board of Behavioral Sciences co-sponsoring this legislation?
Not at this moment, but they also are waiting for it to have a bill number. So their board will review it as a bill, kind of like we review our bills as board, blah, blah, blah. Came out awkward. And then take a position on it. So it is not 3 co-sponsors. It's our bill, and then they would be supporting the bill.
And do we have any early indications or signs that the language that we are seeing here today is more or less in concept in line with what the other two boards are thinking of, or would be inclined to support?
Yes, I believe Board of Behavioral Sciences has already reviewed all of the current changes except for the newest ones. Their board hasn't had a chance to look at those yet. And then Medical Board, I believe, also reviewed it. And then the newer changes, we sent them that in email form to say we were also looking at these changes to make some clarifying points because we had some questions come in from the committee. So,
And you'll do that about the thing, if the board is okay with that, with the things I add, that will also.
we would go to all the other boards, and it sounds like
Well,
because
first we'll have to
the
take a
bill-
motion and
Yeah.
have the board approve it.
obviously you all have to decide whatever we're going to do. And again, right now it's a spot bill so that we can keep working on the language because I think
I'm sorry.
a spot bill means since there's an introduction deadline, it's going to be a bill that makes a really non-substantive, might change an and to an or and a random provision. It's to get the vehicle there. So every bill is like a car. It's a vehicle to get something somewhere. Right now, that's going to be a spot bill. Levine's office would like to work on the language and then also work with anyone else that wants to work on this bill to get language together and that we can all live with and do well with. And of course, we'd want to work with the other two boards to make sure all those changes are.
And to finish
Finish Mr. Fu. I know Dr. Erickson's next, and I know Ms. Marks clicked. I don't know if she wants to jump in as legal counsel. Did you have something you wanted to add?
The only thing I want to add is that we had also ended up including the osteopathic medical board in the group.
Thank you for that clarification.
Psychiatrist as
So the last question is just to clarify that the intent is that we, as a board, aren't going it alone and we've been turned down, but the intent is that we're working collaboratively with our colleagues across the boards and to sort of be all in this together.
Mm-hmm.
Right. Thank you.
And before you go, Dr. Erickson, I feel like in terms of turned down, that's not a technical term because I don't think we were turned down in terms of a submission process. So I don't want that language to kind of be floating out there. I get that how it was described, but it's not a turn down process.
Not like a big red stamp came back to us with a rejected. So it's just not a good fit for the omnibus or sunset cleanup bill, and that's really what they're saying.
Thanks for that clarification. Dr. Erickson.
Actually, Ms. Marks confirmed what I was going to ask about the osteopathic board. Are they within DCA or separate?
Yes.
They are within DCA. Good. I wanted to make sure the osteopathic physicians were mentioned somewhere in the material we have, and it wasn't clear to me whether we had collaborated with them. I was hoping we had, and apparently the answer is yes. So that's the fourth board that there's 4 of us that are working together on this.
And that also was a reference to item number 15 because in that one, the language has been added to the proposed language for the brochure. Dr. Phillips.
I did want to revisit this idea of or unwanted, which I think is very relevant in the context of sexual behavior. However, when you're looking at a therapist engaging in behavior, oftentimes whether it's wanted or unwanted does not change whether it's an appropriate thing for the psychotherapist to be doing. So I think we need to think that through. But I think the concept's very important, clearly.
Any other board questions or comments? Dr. Horn.
To the visiting of the, if we let's say we don't put that word in, we can't think of a word, and then this goes forward, and we want to include that something about that construct there, because you're right, a lot of times things are unwanted maybe in therapy that aren't inappropriate. But so let's say we didn't include it, and then this goes through, and we want to change that. We think of a good word or a good phrase or something for the construct. Can we do that at that point in time?
Late in the game?
Huh?
I would assume so. And
Well, because you just said that the changes, the spot bill is pretty much it, right? And then
No. The
changes-
spot bill's an opening foray, so it's a it's a placeholder bill. So it's like putting an empty car in there with no seats. But it saves a spot to put real language in. So right now it's a sentence or two and it changes one word to another. And then once there's agreed upon language, then there would be a bill.
Okay.
And I think because it is complex, we do have evolving discussions on this bill. And so that's where we might go. But in your reference to unwanted, I don't know if that leads you into the row, on page 2 of the chart for sexual harassment within the APA ethical code or not.
Well, and here's the idea that
Before you go, before you speak, I just wanted to say, in terms of the unwelcome and unwanted comment, based upon what Dr. Horn just said, Mrs. Monterrubio, do you have a perspective on that also, in terms of the level of complaints and the enforcement activity?
Well, I think that some of the cases that we've seen is it initially isn't unwanted. And we're dealing with a vulnerable population that may not realize at the time that that behavior is not acceptable. So we're definitely seeing in these cases, it seems to be happening more and more. So I think
It could be unwanted of a sexualized nature,
Correct.
even just saying, because we have said it's sexual behavior or communication, I don't remember exactly what it is right now, that's inappropriate. But I think inappropriate, some things are clearly inappropriate, it's in our ethics code, et cetera, et cetera. Other things might not be so clear, and yet the behaviors or the communication was taken in a way that, maybe that hadn't been the intention of the therapist, but in fact that was the impact for the client, and I that's kind of what I'm talking about,
So, Dr. Phillips?
Yeah, I guess what I was trying to get at was there are situations, which I think Ms. Monterrubio was referring to, where perhaps the patient wants to kiss or wants to hug or wants to sit in the therapist's lap.
Well, then that's inappropriate.
It's inappropriate, but if we put in or most of the behaviors that we're talking about does not matter whether the client wants it or not.
Absolutely.
Consent is not a defense to doing something inappropriate with our patients.
And I wasn't thinking.
Dr. Horn, some other people have gotten before you. Okay.
So that's what I was trying to capture by the discussion.
Thank you, Dr. Phillips.
As I try to think about it, partially informed here, I think when it comes to sexual harassment in the workplace, the unwanted or unwelcome is what really helps define sexual harassment. That would be a different issue, though, from sexual behavior or sexual contact by the therapist with a patient in therapy. So are we kind of looking at both of these issues in this pamphlet, or is it primarily the sexual behavior, sexual contact that we're looking at?
Really the latter usually.
I don't know the answer, but I'm thinking it's worth thinking about.
And I saw you click, Mr. Quayle. Did you want to ask a question? Okay. So I would say, and I think it's an excellent question, Dr. Erickson, to ask in terms of the enforcement activity and the intent of the proposal. I guess I am interested to see, and currently in terms of our enforcement cases, in terms of sexual harassment complaints, where does that fall, and is there codes that specifically are spelled out? It spells that out for our licensees, and if not, is there a way to get to that point of unwelcome, unwanted contact, actually sexual harassment being labeled in this as well?
Well, my understanding is...
Can I have
No, go ahead.
Can I go ahead?
Yeah.
Okay. My understanding is sexual harassment is covered in the APA Ethics Code, and the APA Ethics Code then in turn is incorporated into our regulations. So I think sexual harassment is not what we're trying to capture relative to this bill, although it's a very incredibly important topic. What we're talking about is sexual contact and the behaviors around sexual contact that are highly sexualized or provocative behaviors that in effect are as much of a boundary violation perhaps as sexual contact. So I think we're trying to capture that class of behaviors if I'm understanding the discussions I've had with Ms. Rubio and Ms. Burns before.
And I guess my question is, given the content about modernizing it and making it more modern, I guess the question would be, is there something in code, getting back to Dr. Erickson's question, in terms of the need, the appetite, the importance to include it in this? And I understand that point too, because I'm with you as I read through the material, hearing some comments over the last few days. I feel like I think that Dr. Erickson's question does spark me to ask that question. I know our initial intent, but in terms of now that we're not a part of the omnibus legislation process where it was a very narrow and we were trying to move it through there, is there a possibility and is there a need, given the enforcement activity that we see as a board, for us to even think about and consider at this time?
Sexual harassment. I'd have to actually go and pull closed cases that have already been voted on. They've been adjudicated. I don't know what percentage falls within the sexual harassment part, but as Dr. Phillips stated earlier, it is a violation of the APA ethics. It's 3.02. It can get pled in the accusations, but I don't know what percentage of the cases we're talking about actually pled with sexual harassment.
I see our DAG representative. Please come to the microphone if you'd like to say something, Mr. Trompley. Sure, you can. Tomplay. I'm sorry, I said it incorrectly.
If we
I
don't
didn't mean it, Josh.
get our words exactly right here, what I'm hearing from you is that we can get them right later.
Mm-hmm. The bill can be amended
Way
along
to
the way,
talk
right?
about this construct. Huh?
That's what you're asking.
I'm sorry.
Really quickly, did you want to just give the brief timeline of the legislative session this year so the board members know policy and advocacy meets on this day, board meets on this day, last day for committees to consider policy bills, just so they know if we're going to suggest any amendments after the meeting today, is that possible? Do we need to have a special meeting? What does that look like?
No worries.
Thank you.
So helpful things to know. So we've got the spot bill. That'll mean you have a vehicle to drive. But when we're talking about important dates, where's it at? Last day for policy committees to pass a fiscal or a non-fiscal bill, this would be in the first house, would be May 11th. So in order to get it out of the assembly, it would be May 11th, which is pretty fast. You have a May board meeting. We have one policy and advocacy committee meeting in the meantime. There is always the chance to continue amending bills up into the second house. So in that one, it would be last day to, where is it at? Second house would be July 6th. So it is still a very fast deadline. So it's not immeasurable, and you are in the second year of a 2-year session. So it's not as simple as the first year where it can be a 2-year process with the same bill and same number. Not to say that you can't go again next year, but it'd be a new legislative session again.
Thank you, Ms. Burns.
Hi, Josh Tomplay with the Health Quality Enforcement Section, the board's liaison. Just some quick input if it's helpful. I think there was a general question posed. Equipped to prosecute, instances of sexual harassment, and absolutely, I actually don't, from my limited perspective, don't see any need for new statutes or new regulations defining each specific type of sexual misconduct. The general fallback position, which is more than reliable, is to charge it as gross negligence, and then, of course, we're relying on an expert to find a departure from the standard of practice. And even if conduct of a sexual nature doesn't fall within the narrow description of sexual contact or sexual misconduct, it's still going to be gross negligence, and that still triggers revocation on down in terms of severe penalties. So just as things stand now, even though we don't have a specific statute or regulation that says, delineates each possible type of sexual misconduct, we're well equipped to prosecute that, if that's helpful.
That is helpful. Thank you so much.
So, Dr. Phillips pointed out that the APA code of ethics, that's a great starting point, and those are all considered standards of practice, but it's just a starting point. So experts, of course, are free to draw on common sense in their own background and experience and find misconduct, even if it's not specifically identified in the code of ethics.
Thank you. Mr. Fu.
For just clear, I think on our chart, attachment B, it under the sexual harassment column, I think it might be helpful because for clarification for a wider audience that even though it's not defined in the psychology licensing law, we might want to include a note that it is incorporated in our regulations per APA, and perhaps we can even include in some general forms of what we just heard, where in addition to what is already included in the APA, that the Attorney General's office is empowered along other lines as well, so that it doesn't leave the impression that sexual harassment isn't considered important. It is absolutely, and so that's why we have included already in existing regulations for that. Is that clear?
Absolutely.
Thank you.
I think Dr. Phillips was before you, Dr. Horn.
I guess, Mr. Tomplay, our concern is, or the concern that I've heard in the context of enforcement, is that there are egregious sexual behaviors that people engage in that do get prosecuted as gross negligence or are subject to an accusation for gross negligence, but oftentimes the penalty does not seem commensurate with the behavior, which is why we're revisiting this subject. And that's not a criticism of the Attorney General or our Deputy Attorney Generals. It's just that it doesn't seem like there's enough bite in it. And some of these behaviors, if a therapist were to send a picture of their genitals to their client, that would be gross negligence. That would not be a sexually egregious enough behavior for us to go automatically to revocation. So I think there's some middle ground there, but I do think there's a group of behaviors that are deserving of more serious attention than just gross negligence.
Point taken. And if I could just make a follow-up point. Also wanted to caution the board as to the most recently proposed amendments. Actually, I would advise against looking at attachment A, page 3, the newly proposed amendment to section 2960.1. So just to quickly review, section 2960.1, this is on page 3 of attachment 3. This is the piece that says automatic revocation will apply to sexual contact. So as things stand now, that's what gives us that automatic revocation for sexual contact. And sexual contact is a very narrowly defined misconduct. It's been carefully defined, I don't know, 10 or 15 years ago. It's the most egregious type of sexual contact. I would advise against broadening that, which is what this proposed revision does, to include the more vaguely and broadly defined sexual behavior, because sexual behavior includes things that I don't think you necessarily want automatic immediate revocation for. You want to have, I think, a probationary option. For example, for a sexual comment, that can be egregious behavior. I don't think that in every case someone should lose their license if they make a sexually motivated comment. So to me, the goal of broadening the audience who should get that brochure maybe became blurred with the definition of which acts should result in revocation without discretion. So.
Good point.
Ms. Marks?
Yeah, I want to thank Mr. Tomplay for pointing out that there are different kinds of sexual behavior that may or may not warrant the same level of discipline. I also want to, point out, excuse me, that the automatic revocation under 2960.1 may not be stayed by the ALJ. It does not mean that the board is bound to make that same decision. And the board can decide that even though the ALJ was bound by automatic revocation, the board is not, and could stay that revocation and put probationary terms on the licensee who's being disciplined. My second point would be that the board would never be would not lose its prosecutorial discretion in how things are alleged and prosecuted. So, for example, I don't think and Mr. Tomplay can correct me if I'm wrong, I don't think, a text that is sent that says something like, gee, I'm on vacation, wish you were here, would necessarily have to be prosecuted as sexual behavior and could be a boundary violation and not allege that under 2960.1. So prosecutorial discretion will always remain with the complainant. So, and Mr. Tomplay can maybe speak to that as well, so that you can maybe correct me if I'm wrong, but I don't believe that everything from a wolf whistle to anything else would result in revocation or have to be prosecuted under 2960.1.
Thank you. Ms. Marks, that sounds fair. Yeah, I'd agree.
Dr. Horn. Thank you, Ms. Marks, for that
So
clarification.
this actually sounds more complex as we're thinking about the language than, but if we could put in something now just to hold the place, then we have till May, is what you're saying.
You'd want to get the ball rolling before then. I mean, that's kind of the deadline.
No, that's what I'm saying.
Yeah.
That's
like the
I
last time you get
understand
the-
there's work that has to
Yeah.
be done between now and May. What I'm saying is we have till May to put in any changes we would want to put in. Is that right?
For the first house.
You could, and I'm looking at Mr. Fu, because you've been firsthand in the process as well. But I think what the author's office has asked is that we get the most clarified language now, and we can always seek amendments once it's in the process, and we can work with stakeholders and impacted boards and individuals, organizations after that point. But unfortunately, we are in a second year of a 2-year cycle, so things are moving a little more quickly, and I know that doesn't always sit well with this board because you guys are a very thoughtful, policy thinking group and you want to make sure that everything is just right, which I understand and appreciate. We're trying to balance that with the legislative calendar.
And I do think that much like the question that Dr. Erickson asked, or the comment he made earlier about the other boards, I think that through the process, as we know, others will have input as well. But I do think that, again, in terms of this process, we did adopt something and we've had some changes to brought forward to the parts that are highlighted in particular. So I guess that is kind of, I appreciate that reminder that we have a calendar that is being followed and is the second year of the 2-year cycle.
So I have one.
One more second, Dr. Horn. I'm going to see if there's any other board members that haven't had a chance to comment yet, if they wanted to say anything, particularly as the enforcement committee chair, or if Dr. Kasuga has anything that she'd like to add to the conversation.
Work together on this and this language as well. I think that would be important, and I'm asking you, Ms. Monterrubio.
Well, as you know, we're going to be working on the disciplinary guidelines in March, and we have other items as well. So I don't know if it's the wishes of the committee, but it just seems like we already have a very impacted agenda. So to take this on as well, I think would really delay the process,
So not
especially if we have a deadline of May. I don't foresee the enforcement committee being able to.
but we will keep in touch with them, and that's what I'm saying. To see what
Actually,
it looks like.
Mr. Quabadu is going to go to the Policy and Advocacy Committee, and we're having a meeting the same time you're having your meeting, and it'll come back to the full board.
Okay. But I'm saying before it comes back, can we just have a conversation with them around this particular issue?
Oh, like
That's all I'm
a
asking.
quick update to
Okay.
you and
Yeah, that's all. A quick update to us to make sure that we are aware of how they are moving and what they're saying and the language that they're using. That's what I'm asking, that we do that. Thank you.
Dr. Kasuga, do you have anything you want to add?
My thoughts were just like that. We're gonna have the policy and advocacy committee meeting in mid-March, and this will be. I don't have the agenda yet, but like this will be one of the things that will be focus on that.
Yeah, you don't have the agenda yet because the deadline to introduce is today. So
No worries.
yeah, we usually want to give you guys the most up to date bills and information. So unfortunately, we wait till the deadline to introduce so we know what the universe looks like, and then we can start detailing bills that might impact the board. So that's kind of a separate from this one, but that's why the agenda for policy and advocacy comes a little later.
So I know that people in the public probably have some comments as well, but before we go to public comment, and I know you Dr. Horn too, before that, you get your last point, and I just want to just ask the question to the group too, as we're thinking. I think the other important part is that I know, as Ms. Sorick mentioned, we are very thoughtful and we want to make sure we take all the steps. But in terms of the timetable and getting back, we are working on a timetable. So we've got to move forward. And so the spot bill piece, the securing of the author, was basically at our direction to staff to do when it got approved in November. So the information, so we're being asked today to look at what's been submitted and to be able to report back to the assembly member and to the other 3 boards that we've been in touch with. And then again, at the time of the policy and advocacy committee, we will look to see what the status of that bill would be at that time. But we are starting on the train and it's going. So before you make your comment, Dr. Horn, too, make your comment, please. And then if there's anyone that wants to entertain, we want to entertain a motion, or do we not want to entertain a motion to accept what's been provided to us here? Because then we also will be able to open it up to public comment as well. Dr. Horn.
Okay, so given my understanding of what you said, I don't. The definition at this point, to my mind, of sexual behavior means inappropriate contact or communication of a sexual nature. Inappropriate is the key word there, and I'm fine with that, and we don't have to add unwanted or anything, just even for this. But I would want to uncapitalize licensed educational psychologist or capitalize everybody. That would be my. That's all I'm saying. So I would like to move that we accept this language so that this can be moved on, except with that one suggestion, licensed educational psychologist, so it can be moved on in the legislative process.
I'll second.
There's a motion and a second to adopt the language with the minor correction of changing how a licensed educational psychologist is listed with no capitals. And I just want to say again, thank you, Mr. Tomplay, for giving that information to us, and Ms. Marks for explaining what 29D.1 would do and what can't be done. So seeing that we have a motion on the floor, before we take a vote, is there any public comment about this matter? And I'm going to start off because I know earlier we've done public comment differently. Everyone will have 5 minutes, and you'll have one opportunity to speak during each item, because I don't think it's fair for some items if people come back more than once, because earlier we made people only speak one time for certain items. So please come forward, Dr. Jolinder Crow, and there's 5 minutes, please.
Yeah.
Is this on? Yes. Dr. Jolinder Crow. I'm the CEO of the California Psychological Association, and I will say I appreciate very much the process. I would like to maybe say right now that 5 minutes to talk about something this complicated doesn't seem to me to be sufficient opportunity for public comment, and I just want to go on the record as saying that, and I rarely say that to this board, but this, I know.
I feel like maybe we'll say 10 minutes. I don't think it's fair, because some items we limited to people not having more than one opportunity. I just want to make that fair. So maybe, is there a way that we can make it fair?
I thought public comment was just public comment, and
I just wanted to just give everyone an opportunity.
okay, well, I don't want to use up my 5 minutes, so don't start the clock yet.
She's paused it. No, I mean the board can put some reasonable limits on that, just so that they can get their business done. But it's what you think is reasonable. So.
Dr. Crow, not taking your time. I just want to make sure, I don't know how many people are going to speak on it. So go ahead and talk as much as you want. I just feel like earlier we put time limits on other people when they spoke.
You didn't really put time limits this morning with the people from the Center for Judicial.
Yes, we did.
Yes, we did.
Well, it was pretty long.
5 minutes.
5 minutes. So.
Okay, let me just get going.
But know that I also heard that some board members have more comments. If we have a need to take more, it's going to be fine. But it won't be fair for us for the whole meeting to only allow everyone else to come up more.
Okay. I'll just.
How many people do want to speak on this? Okay, so we have 2. So go right ahead.
Okay. I don't want to have to talk fast like that last part of those commercials, but I do want to give some context for the board that I think may be important in your decision making. And Dr. Horn, you raised a question earlier about why the committee decided not to include this in the omnibus bill. And I want to provide a little more context. I would have thought the board would have known this, but perhaps not. So in November, and I also just want to ask you about something you said. In November, my recollection at the board meeting was not that the board approved language for legislation for a spot bill, but that the board approved or directed the staff to move forward with sending the language to the Senate BNP and ED committee so that it could be included in the omnibus bill. There was no mention of legislation separate from that in November as far as I'm recalling. Now, you can correct me if I'm wrong. At the November meeting, when this item came up, both Dr. Winkleman and Dr. Schaefer gave extensive feedback to the board about some concerns that we had at the time about the broadening of language that could potentially have some unintended consequences about, allowing appropriate therapeutic interventions for people who are seeking treatment around these issues, these sorts of issues. When the language went to the committee, we could not, first of all, we didn't see the language beforehand, and part of the process, part of what I want to talk about is the process. I believe that would have been a good opportunity for us to collaborate on language, for the staff to reach out to the staff. I know the board has restrictions. Then our office got a call from the committee asking us to look at the language to see if they could include it in the omnibus bill. When we reviewed the language at that time, we couldn't see that any of the feedback that we had given at the board meeting in November had been taken into consideration. So naturally, we had to say, yes, we do have a problem with this language. So that's where, from our perspective, that's where this got started. So we provided feedback to the committee, fairly extensive feedback, the same feedback that we had given to this board in November. And I think that's the reason that it couldn't go forward into the omnibus bill, because normally, as Ms. Burns said, an omnibus bill is for cleanup language, not language that they suppose is going to have opposition, which we said to them, if it goes through like this in an omnibus bill, we would have had to oppose the omnibus bill. And no one wants to be in that position. So that's one fact that I wanted to share with the board just to offer some context. We learned earlier this week that you had been shopping for an author for a bill. That's the first we knew about that. So, we're trying to sort this all out in a very short period of time. I guess from a 30,000-foot view, I would reflect part of what our DAG here said, and that is, we're wondering if this is a solution without a real problem. We feel, and I think that some of you have mentioned this here, that this board has already included the APA Code of Ethics in statute as a part of what psychologists have to follow. So we have language too I mean, we've been working on language too since Monday. And we can all get into the weeds about language if we need to. But I am a little concerned about the process. And now, as Dr. Horn said, here we are way down the road talking about a piece of legislation, which is really very time intensive for all of us, very complicated, as you have heard. As you begin to talk about it, you see how complicated it is. And, we're just, I guess what I'm wondering about is what the rush is to introduce a bill. It seems, from my perspective, that we could have easily gotten to yes, as they say, on this, and gotten language that probably maybe even could have been accepted into an omnibus bill at some time. So in November, we were just talking about a modernization of the brochure, which makes sense. And we should all, I should back up and say also that we all start from the same perspective, that we want to say to psychologists, you cannot engage in these behaviors. You cannot. And I'm interested that attachment C actually had language from cases, I understand, closed cases. So that is evidence to me that this board does take action on inappropriate behavior that psychologists engage in, because the language that you see in attachment C, all of those behaviors are cases that you decided on. So I'm just want to raise this for the board to consider, that you already have this language in statute, as you see in that grid, many statutes that relate to this. You already have the Code of Ethics built in. And I share the concerns of the DAG that when you start listing particular things, all that means you're leaving out other things. And we'll never catch up with the technology and everything that's evolving. So there is judgment involved, both on the both from a psychologist in their practice. They are bound by the Code of Ethics. It's in the law. And there's judgment there, and then there's judgment on the part of the board when you see these things come forward in complaints. So I am struggling, I guess, with the notion that we've ended up here's where I think none of us want to end up. So none of the professional organizations have been involved in this discussion to date. Not really. We gave feedback that was not included. So, there's not just CPA, but with these other boards involved, they're going to be the professional organizations. Sometimes we think there are issues, it's rare with us, actually with our board here, that we disagree on things. And when that happens, it's because there is some real substantive difference of opinion. Here, I don't think there really is. We absolutely agree with what you're talking about. And I'm just concerned that we're transferring this over to the legislative arena, which is much more combative than it needs to be sometimes. And so I wonder if we could just consider, if the board would consider, maybe taking a step back and maybe working on language to modernize the brochure that would have probably sailed through an omnibus bill if we could have gotten the language right. And I doubt that it, from our perspective, it wouldn't have been very hard to get the language right. So I just raised it because we're just concerned the notion that we're going to over broaden the language and have the possibility that legitimate therapeutic interventions may be caught up in that is problematic for us. And we are about consumer protection too. And, we want those patients who are coming to psychologists for treatment around issues related to that are sexual in nature have the ability to get the kind of therapy they need without a psychologist having to second guess every word they use. And again, starting from the premise that we are in absolute agreement that these behaviors that people get disciplined for, they should get disciplined for. Absolutely. And actually, we trust this board to make those determinations already. We have absolute faith in this board to make those determinations already. Elizabeth, do you want to?
Are you done with your public comment? Because before we take the next public comment, I was going to ask the staff a question based on what you said.
Yeah, I'd like to see something too.
I'm just looking at my notes.
I want to make sure, and I didn't.
One question. No, I'm.
About the time.
I totally understand, and I certainly hope you didn't take what I said as being disrespectful to the board. Do we know if a spot bill has been introduced today? Should be or has? Should be. Okay.
And very, in one sentence, generic. It's true spot.
Right. So a true spot bill is just that. It's a placeholder. I think the danger in spot bills is that it's always really easy to say, we'll just do a spot bill and then we'll just work it out. And the working it out piece is much more complicated than it appears sometimes. So I guess my last comment would be that if the board, and completely up to this board, of course, to decide whether you want to introduce a piece of legislation or not. One request that we would have is that if you do move in that direction, we would like to ask that the bill not be sent to even the first committee until there is consensus from all stakeholders about the language. That would be our request, that it not go even to the first committee until there is consensus among stakeholders. That would be us, that would be other professional organizations, and the other board, depending on what happens with the other boards.
Just to make sure I understood what you said before you finish your comment. You basically are saying that you want the board to consider making sure that after the spot bill is, because today is the deadline, the spot bill would be introduced today, that before we submitted the draft language to the author, we would need to get consensus. You are suggesting that we get consensus from all the stakeholders involved before that got submitted to the assembly person. Is that what you were saying? I just wanted to make sure.
No, not quite. That before the assembly member moves it to a committee, that we try to get consensus on the language. That happens all the time. You can always withdraw a spot bill. Or you can work on amendments with all the stakeholders to get language so that when it goes to that committee, we all don't have to show up and have this conversation at the committee level. That it could go to the committee and say, yes, we have agreement from the California Psychological Association, or anybody else that has a concern. If this is what the board, if you choose to take the legislative route.
So I just want to make sure I understand what you're saying. You're saying as the board of psychology, you're telling us to make that request of the assembly person.
Well, I'm not telling you.
No.
I'm asking.
No, you're asking us.
I'm saying that would be our hope, that that before it went to the first committee, that we would have worked together on language that is acceptable, so that we are all clear about what the language is and is not doing, and that the consequences are clear.
No, I understand what you're saying. I just want to make sure you're asking what we're doing, because we don't move legislation in the legislature. So you're asking us as a board to ask the author not to move it forward. Okay,
I suppose I am asking that. Yes,
we're clear. Okay, that's all.
If you choose to go forward, that one of the pieces of that would be for Assemblymember Levine's office to understand that consensus would be important before it went to the committee.
I just wanted to make sure, and
no, you're right.
You're right. What we're doing, because we don't move legislation.
No, of course.
I wanted to make sure. Thank you so much, Dr. Linda Crow. And before board members get in, I just wanted to ask the question, and actually Ms. Sorek will go first before board members. Just a follow-up question in terms of that understanding about, I'll hold on to my question. Go ahead, Ms. Sorek.
I just want to make a quick comment on process because this is not the first time this has been brought up. So I just want to make sure the board members understand that staff moved forward with the language that was approved in November, given the restrictions on time, given the legislative calendar, that because the Senate BMP committee did not accept it because it wasn't a sunset cleanup, that we could still move forward with the language that the board approved. So I just want to make sure that we're very clear that staff did not go off on its own and present language that the board had not agreed on to present to the author for consideration. I just want to make process-wise that clear.
Thank you, Ms. Ork. That was my question, so I wanted to get clarity on that one. Dr. Erickson and then I think Dr. Horn, it was Dr. Phillips, I'm sorry. I don't know who was on this side. I think Mr. Fu, did you also want to get in? Okay.
Dr. Linda Crow, I appreciate and agree with virtually everything you have just said. One thing caught my attention, and that's, I believe, for all of us to remember, the brochure is for the public, not for psychologists. Mm-hmm. And so I'm trying to keep my sights clear on what we need to tell the public, and I think we have an opportunity to better educate the public about inappropriate sexual behavior or contact from their therapist by having this brochure available. The other thing is Mr. Tomplay's comments left me with the question of whether we, and I don't know the answer to this, whether we need to revise the regulations. Maybe they're sufficient as they are, and we just need a better brochure. Do we have the regulatory teeth that we need to go after people that do modern things that aren't listed specifically? I'd be interested in staff or other comments on that question.
I would lead into it and then I'll hand off to obviously our enforcement manager who does a lot of this and that's her daily job. While you have taken action on some of these, a lot of them we didn't get revocation for quite a few unless they actually had sexual contact included in that. So all the behaviors that lead up to this sexual contact, sexual intercourse with the patient, however many sessions it was over, those behaviors, they weren't the things punished. It was the contact. And so some of these behaviors that were in some of these closed cases, they aren't. So it's where I would go with that.
That's correct. So many of these that are here as examples of attachment C were placed on probation. The cases that involve sexual intercourse, according to 2960.1, we obviously seek revocation in those cases. And I also just want to talk briefly about the process. When we get a complaint, it's typically not the he said, she said. Like, he kissed me, and then we contact the licensee and says, no, I didn't. We have to have proof. We have to be able to substantiate those allegations. And typically we get copies of text messages, copies of cards, things, again, that can substantiate what the victim is alleging. And then we move forward that way. And we're just seeing that there is a lot of grooming behaviors, and we were trying to prevent or stop it at that point before it escalates to intercourse, the actual sexual contact.
So could I just, no, 1 second, Dr. Crow, board members are having an opportunity.
So Ms. Bonarubio, if I understand what you're saying correctly, you do not feel like you're adequately able to enforce them under the existing system by which that becomes an example of negligence or gross negligence. It doesn't lead necessarily to the result appropriate to the particular case from the point of view of the enforcement department.
Correct.
Okay. Yeah, so...
1 second, were you done with all your questions, Dr. Erickson? Pretty much. If you had more, it's still your floor.
I'm done for now. I just appreciate us looking at this.
Okay.
And I do appreciate what you're saying, Dr. Linda Crow. You weren't here in November, if I recall correctly. We did actually take into account the comments that were made. The language that was approved at that particular time did not include reference to appropriate therapeutic behaviors. If you note, the materials that we're looking at now have added a sentence which were directly responsive to some of the
I
concerns
see.
that were expressed. So
I see that.
I don't think we're being unresponsive. You may feel like we're not being sufficiently responsive, but I understand that. I think there's a variety of different ways we can go with this whole thing. I think we could get more particular in the definition and particularize, but I think the more I've thought about that, the more I've felt like that's not going to be a very successful strategy. As you say, it's not necessarily, another new behavior is going to come up.
Right.
There's going to be a new app that does something weird, and we're not going to have it in our list, and it's going to go back out there. I do think there's a certain amount of vagueness in the definition of what is sexual behavior as opposed to sexual content.
In the statute, you mean? Or in the ethics code?
In the proposed statute. I don't think the ethics code's sufficient. I mean, I've read the sections you guys highlighted for us, and I don't think it's sufficient. And sexual harassment's not really what we're talking about. We're really talking about almost sexual assault, really, against clients one way or another. So one way we can do this, which may make the most sense so that there is room for sufficient deliberation, people feel like there's enough input for the stakeholders process, would be for us to bifurcate this issue in a way, like you bifurcate trials into an issue of whether people are liable and what the damages are. In this case, what we would do is bifurcate the materials necessary to bring the brochure up to speed, because that definitely needs to be changed. That brochure is wildly out of date. I know it's been revised sometime in the 2000s, but the content really hasn't been revised since I was in graduate school, if not before. And now that's getting to be a long time ago, I'm afraid to say. So I think we could bifurcate it so that the question of adding sexual contact as a separate class of things that we're going to take more serious enforcement action on is something maybe we should take a little bit more time on, so that we get a definition that, even if we don't agree on the definition, you'll have an opportunity to have more input in the definition. It would also give us an opportunity to address Mr. Tomplay's concern, which is we don't want automatic revocation for kissing a client. I mean, it's crappy behavior and you shouldn't be doing it in all likelihood 99.99% of the time. But it's not necessarily one that would rise to the level of revocation, and yet it is still sexual behavior. So I was one of the people that went and made some of the legislative visits on this, so I may be betraying the people that I made the legislative visits with, but I feel like we should really take our time and make a very considered decision as to what we're going to include within sexual behavior.
In the statutorily, you mean?
Statutorily, so that that would be a separate statute.
Mm-hmm.
This first statute, we kind of like cut it down to what was necessary in order to get the revised brochure in place, because I think that definitely does need to happen. How we do that, we'd have to work with, obviously, the Assemblymember Levine's office and the other boards to see if they'd be amenable to this. I mean, the whole thing's kind of a mess.
Let me ask the question. So thank you for your perspective, and we'll get some other folks on this conversation. In terms of making the changes to the brochure, and back to your question about what would need to be changed, is what Dr. Phillips suggesting, staff, would that be able to be successfully done? And Ms. Marks, is that something that you would advise us to look at as a board?
I think whether or not you proceed as Dr. Phillips has suggested is really a pure policy call. I think what you're suggesting language-wise would then potentially be to move forward with some suggested changes to 337 and 728, but not 2960.1 at this point. Is that so that the trigger language for providing the brochure is changed, but the basis for discipline of adding of sexual behavior to 2960.1 may proceed at a later point. I think that's what Dr. Phillips is suggesting. So whether or not you do that is a pure policy issue, but I think that's how it would be done language-wise.
Thank you, Ms. Marks. And then for staff, given what you just said, Ms. Monterrubio, about our complaints and our enforcement activity, I know that the brochure being updated is one item here, but the other in terms of the cases that we've seen and that we've not been able to move forward on and to protect the public's interest, quite frankly, is that something that we feel like we can delay this and maybe put it on some kind of timetable, and what's your feeling about that suggestion coming from the board?
I think that's fine.
Any other?
May I make a comment? It just
Not yet, Miss.
Okay.
Not to. I gotta make sure the board members get a chance.
I know. I'm just coming. Okay.
Mr. Fu, did you want to? I thought you were earlier. Dr. Kasuga.
I do have a comment in relation to what Dr. Stevens said, and it's also related to what we talked about last November with the updating of the brochure. It's not just to modernize it, but it's also we were hoping to be more effective in getting the public, the clients, to report what they would otherwise not assume as reportable. So that's kind of like a twofold goal of updating the brochure. And that's like what we were talking about in November. Just wanted to kind of like clarify that.
Thank you for that reminder in terms of what we're really trying to get done. And back to that question of why it's important and the timeliness of it. Dr. Horn?
So I like Dr. Phillips' idea of the bifurcation of these two things to include the language that, except for the last section, which is 2960.1. Because that is something I think we want to discuss about how broad we want to make that or how we would want to state that. But with those just slight modifications, because we have in here the appropriate therapy, but that would allow us to make these changes on the brochure, and then we would work with stakeholders to make sure that the final language for what we bring forth would more reflect what we can all agree on. So I'm supportive of that suggestion. And
so we're going to go.
making a motion.
Well, we already have a motion on the
we
floor.
do have a motion.
So we'll continue with the public comment, then so you're suggesting that we need to change the motion. I will just say also, as we kind of close out this conversation, if no one else has anything to say, I think as we work on these definitions, and I think the suggestion by Dr. Jolanda Crow was important about working with other associations, but stakeholders in this case, as we were reminded by Dr. Kasuga, includes the public. Folks that are actually those affinity groups, the counties, the folks that are actually providing services, or not providing services, that are working with folks that are receiving services. So I think that we need to make sure that we do think about that net a little wider. Seeing no more comments, Dr. Linda Crow, you have one more comment, and then we're going to let the other person who
I
wants
just wanted to say that I appreciate the conversation, because I think part of it clarifies a lot for me, that I do think you're right that two things got conflated a bit. The brochure, and then what I'm hearing is that there are also concerns on the enforcement side that somehow, as you put it, there's not enough teeth to take action in some cases. So that explains a lot to me, because part of the mystery was how we got from revising a brochure to introducing, to revising the B&P code. And I see now that the two things kind of went hand in hand in the end, and it made it seem like it was necessary to do the legislation. So that helps. We also have language that we have been talking about that's very similar to what you all have been talking about, whether it's a word like unwanted or inappropriate or unwelcome. And so I believe that on those issues we are certainly ready and eager to work with the board and the staff on the kinds of language that would probably end up where we all want to end up on this. So I really appreciate the conversation for allowing me to get that clarification for us moving forward. So really appreciate
Thank you,
it.
Dr. Undercrow. And I will just say, I think if your final point is important, and that's why that item number 15 with the brochure and this conversation are so tightly linked. And so thank you for your public comment. We're going to take a few minutes of a biological break here, and then the next person, Dr. Winkleman, you'll be up next for the public comment. That was the only other person I think that wanted to speak. I see another person, so that's why we'll work on how we limit and we make it fair, because I don't think it's fair for one person to have more than everyone else. So we'll make it fair. We'll take a 10-minute break, 2:51. We can come back and have Policy and Advocacy Committee. Okay, so we're back in session. I know we had 2 more people for public comment. If you could approach, please, Dr. Winkleman.
Sorry.
Just keep talking. I think it's working.
Okay, it's on? Okay, great. Hi, Dr. Elizabeth Winkleman of the California Psychological Association. Thank you for having this dialogue with us and for the opportunity to provide comments. I did notice that after the last meeting there were some changes that were made to the language in this section referring to appropriate therapeutic interventions. And I do appreciate that. However, I still do have some concerns even with that addition in terms of the current language for similar reasons that Dr. Schaefer and I had mentioned the last time. So what I would like to say is that in addition to the 2960.1, which it seems the board may be considering to hold off on that, I think that the 728C3 definition of sexual behavior, even with the addition of the language about not including the provision of appropriate therapeutic interventions, may need a more thorough revision as well. As Dr. Joe Lindercrow mentioned, I think that all of us would probably be able to come up with language we could all agree on, but if that were the process, if there was some process going forward that would enable that. But as it's currently written, I still would have some concerns that it's potentially overbroad. And so to talk, to follow up a little bit again on the next, on what we discussed at the last meeting, is the concern is where we're all on the same page in wanting to protect consumers against misconduct of psychologists. We also don't want to restrict behavior that's appropriate in terms of therapeutic behaviors that address sexual issues, because that is a part of treatment for certain people and couples therapy and relationship issues and so forth, and in many times. So we want to make sure that the language is not overly broad as to be overly vague or confusing or potentially restricting therapeutic interventions. So as an example of that, there's some in the attachment C, for example, the second bullet what is that patient, client, supervisee, intern, kissing therapist, where therapist fails to stop the behavior and inform why it can't happen again. I think we all know that if some, if it were really, inappropriate sexual kissing, that would not be okay. However, for example, if you work as a therapist with a person for several years, on their last session, they may lean over and say goodbye and give the therapist a kiss on their cheek. And I think that probably members of this board have had that happen. And I certainly wouldn't want to have to say, oh, please stop, and that can never happen again. So I think we need to be really careful in what language we use and what examples are given in terms of inappropriate behavior that is, in fact, misconduct and punishable. And I wanted to suggest that in looking at the language that we take another deeper look at the ethics code. And by the way, I very much appreciate the staff's putting together this chart, which is really wonderful, about the different sections. It's so helpful in a complex area of the Business and Professions Code, the ethical principles, and the Omnibus Proposal. And as was noted, the ethics code is incorporated as the standard of care by California law. And all the psychologists are also know they need to abide as members of the profession of the ethical conduct of the APA. So that language actually on the page 204 there that defines sexual harassment is actually very broad, and I think it might be something, if we're going to work on coming up with new language to define inappropriate sexual behavior, that it's worth looking at that, because it's not, it does cover things like inappropriate sexting and so forth, and I think it may be possible to incorporate that into any new definitions, because it does include verbal or nonverbal conduct that sexual in nature is unwelcome, is offensive, or creates a hostile workplace or educational environment, or is sufficiently severe or intense to be abusive to a reasonable person. So something like that, a patient hugging you on the last session would clearly not be unwelcome, offensive, or creating a hostile environment, but gross misconduct would, or psychologist misconduct would. And then the only other thing that I wanted to bring up and really ask as a question is, I hadn't realized that there was potentially insufficient ways to discipline psychologists. The discussion in terms of 2960.1 implied that, I'm unclear, my impression was that you could revoke a license for other reasons, that they would not have to be, in other words, gross misconduct, that you could revoke a license even if it was not sexual contact. So that was really a question for the board or the board staff in terms of, is it possible to revoke a license for other reasons other than sexual contact?
Yes, the board can revoke a license for other reasons than sexual contact. Absolutely.
Okay, so I think that also is just something for clarification in terms of the purpose and needs of how these particular code sections are going to be revised. So. Thank you.
Any board members have any thoughts they want to add or comments? Thank you.
Thanks.
And staff, thank you for responding to that question for Dr.
I do have
McLuhan.
one quick comment.
Sure, Dr. Phillips.
We look forward to your participation in the process.
Me too. Thank you very much.
Should that get approved? I mean, we have an information on the floor. So, Dr. Schaefer, please.
In thinking about this process, I thought, maybe part of the reason why the board has been moving, what seems to me at least to be a little quick on this, might be even for the purpose of helping staff. It must be daunting when you get these reports in and not having something that's highly specific as to which behaviors would constitute the need to move a report forward. It might create kind of a backlog. So I don't know if that's part of what the concern might be, and if specificity in trying to carve out exactly what behaviors we're speaking of would be helpful if that's part of the process. I do, however, think it would be prudent to hold back and wait and give more thoughtful time to it. But, here's my sense. I know, and Stephen, you were saying how, Dr. Phillips was saying how it could be spiffed up. But in reading it, which I've used for years, everything we're talking about is right here. It really is here in your first sentence. It also never includes verbal sexual advances, or any other kind of sexual contact or behavior. When you go to page 7, it talks about sexual exploitation, sexual misconduct including a broader range of activity which may include fondling, kissing, spanking, nudity, verbal suggestions, innuendos, or advances. I think you have both verbal, nonverbal, and behavior, direct behavior outlined in here. You have on page 8 a whole list of warning signs that ostensibly most of them you included, I think, in your attachment C, which could certainly be, you could even frame that if you want to as possible reasons for you to make a report should you have that concern. I just wonder, what do you think is really missing here? I think there may be something lost when you try to get too specific. I think there's actually a benefit in being more open to the terms and not defining the terms, because I think in a lot of these types of cases, it's really in understanding exactly what happened and doing the due diligence of listening to the case and looking at what happened to determine whether it is of import to move forward with. So I think perhaps more definition may be a disservice to the integrity of the process rather than enhancing it for the purpose of possibly a quicker outcome. You're welcome.
So just a little bit in response to you, I think part of the our difficulty, I think, was identified earlier, is that we were mixing the two parts. We needed to get something there so that we could make changes. And but this isn't going to be in the law, the attachment C. This is just some, these are just some suggestions for how we can conceptualize that last part, which is 29, wait a minute, let me find it, 2960.1.
Yeah, some of your attachment C is actually on your page 8 of the brochure. So it's an already there somewhere.
Yeah, but what I'm saying is they're two separate things now. I mean, as I'm understanding it, that we're trying to just get the legislation in, get the bill in, so that we can make changes in this. Yeah, it's okay, but it's out of date. The right groups aren't, that are currently in legislation aren't really the groups who are working on it. We're adding groups, we're changing things, we're modernizing it a little bit. That's what we want to do, and that's why we're going to change this.
Okay, so that's you're saying, Dr. Horn, that that's the motivation to move forward, is to have that opportunity to make changes.
This last part, 2960.1, I mean, we haven't voted on it yet, but the recommendation is that we take a look at separately and think about how we want to do that, because in fact some of these kinds of behaviors that do occur, what we have noticed sometimes when a case comes to us is, and y'all might have seen it in some of the materials, I think when we have cases that do come before the board, it seems like there's not necessarily an understanding that what happened with the psychologist was indeed sexual misconduct. Because there's kind of a narrow understanding, I think, about sexual misconduct. And so maybe some of the things weren't looked at like as sexual misconduct that were. So part of it is that too, if I'm understanding.
You mean, if I could ask a
And also, ask
understanding.
Dr. Schaefer, 1 second, please, because you could ask the question back to Dr. Horn, but also Dr. Horn is giving her perspective, so it's not, you're not speaking on behalf of the board at this particular time, because I don't think we've had a chance to come back as a board to discuss this bifurcation.
This is my understanding. We haven't said the bifurcation, but this is just kind of.
Yeah, I assumed you were trying to speak to me from my comments. I'm conversing back to you in response to yours. So if my understanding of what you said is correct, then you're saying that the purpose of some of this is to help the staff of the BOP who has some challenges trying to understand all the...
Not our staff that has the problem.
Okay.
I think...
someone else?
I think some of the maybe judges and stuff like who are taking a look at this don't understand sexual misconduct.
So then an alternative direction to go might be to do for the BOP, or maybe with the help of CPA, to develop some educational interventions for judges and such. And I know that we find that humorous probably for more than one reason, which I won't mention, but in dealing with substance abuse, for instance, one of my specialties, including trauma, and dealing with doctors, MDs, in clinics, a lot of education had to be done, and I developed programs to educate doctors just on asking about alcohol and drug use.
And I won't kind of go back and forth. Yes,
Yeah.
we've thought about that. We've actually talked about that
Yeah.
on this board, and you've probably been out in the audience when we've talked about that. But a piece of this is if it's not in the law, we can't do it.
You can't educate them.
No.
Ah.
We can't call it sexual misconduct.
Mm.
So things have to be found that are actually, we have grounds to find. So that's what we're trying to.
I understand. Just back to my original, the tenet of which I started with is you have both verbal and behavioral already covered within what you have. And outside of just thoughts, it's verbal and behavioral. There may be some other meta communication, but I think you're already covered. And I really do think that we may collectively, and certainly the board, limit your ability in some way, or other circumstances may come about by trying to define things so narrowly, as opposed to using a wide lens and taking each case and evaluating it. So anyway.
Thank you, Dr. Schaefer. I know you have your thing clicked, but I know Dr. Erickson had said when we started public comment, would board members have a chance to respond? So can I start with Dr. Erickson and come back to you? Because I know you said earlier you had some comments. Do you still have them?
I like the bifurcation idea. I like the bifurcation idea. I think I understand that we need some legislation in order to change the brochure as well as to change 2960.1, and those could be separate issues, and that's what we're bifurcating.
Well, that's one of the things we're discussing in the possibility of.
No further comments then.
I guess the one comment I wanted to make and get some, maybe I could ask it as a question to you, Ms. Monterubio, is it's not a question of staff not understanding what behaviors are inappropriate. It is a question of feeling that there's some very egregious sexual grooming behaviors and other sexualized behaviors that you're not able to adequately enforce with regard to.
Correct. I think staff has a clear understanding of the issue that we're discussing. I think, as you stated earlier, Dr. Horn, it's the outside that we're dealing with that maybe aren't understanding what we mean by sexual contact, sexual behaviors. And that's, I think, what we're trying to clarify here.
Go right ahead. Hit your button.
Agreement with what you've said, Dr. Phillips and Ms. Monterubio. Broader language, I'm thinking, is better. However, we still want to get at the new kinds of things that are happening. And I think you mentioned this earlier. The sexting, the showing of nude pictures on all of those things, while they are not in this, but that needs to be gotten at some kind of way, and that's the language that we probably want to look at or deal with or whatever. So yes, I do. I see exactly where we're coming and why that's so important. So there does need to be a change in order to get at that.
Mr. Fu.
From my perspective, I just want to thank staff for bringing this forward today and for thinking about this. And there is an urgency in the sense that this is a timely conversation, not only for this board, but frankly, outside of in the halls of this Capitol and outside in this country today. And so I would be remiss if I didn't thank staff for keeping us attuned to that and for recognizing that there is an urgency in discussing this and that it is a timely question to bring to us to discuss. So thank you for that.
And I know before we take a vote, or I forget who even made the motion, Dr. Horn, we might want to be able to revisit it. But I do also want to say, as Mr. Fu, thanks staff. Thank you for bringing this to the attention of the board. I agree. I don't know if I totally agree with the illustration of the action of moving too quickly. These issues are far too important and great and harmful to those individuals that have complained to the board, and the fact that I think the intention and notion in this room, as we discuss, people know the difference. People obviously do not know the difference when we have uptick in complaints in general, as we talk about our budget and looking at enforcement staff. So I do feel like on some level I like this idea of let's bifurcating it out. On the other hand, I feel like this issue is such an important issue, and if we are not protecting people that in a lot of ways put so much trust in professionals to do services, I think that we are not, I think it's a little bit of not negligent, but I think it's unfortunate for us not to do it. I don't think it's taking action just because of the current climate. I think it's an issue because of the nature of the issue, quite frankly. I also want to say that I agree that clearly we will never always be able to get it right and define it as things change, which is why every year we have a legislature that looks at all the bills and all the laws, because things constantly change. I do think that, and I appreciate Mr. Tomplay, I don't think that we get you enough to the microphone to share with staff to give us this perspective outside of the DAG's opinion on a hearing. I think it's important to know that, but I also think what Ms. Marks said was really, really important for us to remember what we can do and what we can't do. So I will say to Dr. Horn, she made that motion, if you want to withdraw it, it's your turn to do that, or if not, we should go ahead and carry the vote of the and I see public comment, so we'll come back to you. Is there anyone else that wants to do public comment? Because we're going to have to cut it off to be able to do the next step in the activity. But please come forward, and then Dr. Horn, you can decide if you want to withdraw that and/or we need to call the vote and maybe take another measure.
Thank you. Kathleen Russell, Center for Judicial Excellence. I do not want to belabor this much longer. It's been an exhaustive dialogue that you've had here. But I couldn't not say something based on comments I've heard today that did sort of harken back to me to like 1960s in terms of wanting there to have a definition remain narrow. And there were two different, I believe the AG's office and a representative of the CPA were saying that you should be able to kiss a client when you're saying goodbye to the client. I've been a consumer of therapeutic services. I know many people across the state that have been, and it's never appropriate to be kissing a client. I'm sorry. This is 2018, and if you have a good nurturing relationship with the client and you want to have an affectionate whatever, then they're not going to accuse you of sexual harassment. This is about power dynamics, and a therapist has a tremendous amount of power over their patients and their clients. So I commend the board actually for wanting to broaden and be more specific and get more current with what is sexual misconduct. I think part of the reason our organization is concerned that so many complaints are being denied is probably because of the too narrowly defined misconduct. So we support you in that. Thanks.
Thank you very much. Any other public comment? Dr. Horn, do you want to withdraw your motion?
I'll withdraw my motion.
So there is no motion on the floor. Is there a motion? Can we entertain a motion for action? Dr. Horn.
So I would like to move that we bifurcate this issue. We send forward the proposal, the language, except for 2960.1. And that move forward, that allows us to make with that one little, don't capitalize LEPs.
I got that one.
But as amended. And, but then the next part we take up.
The motion right now is to adopt everything minus 2960.1, and then we'll do that. It's cleaner, we did earlier.
Okay.
Do it separately. Does that make sense, Ms. Marks? Yeah.
Oh.
Is there a second? Is there any board comment? I know we have to do public comment again because we have a new motion, but I will just say I personally do want to speak on this in terms of I want to encourage us, because this has been something we've approved in the past, and not to mention the relationships we've developed with the legislators. And so I just feel like it's an important one to just keep in mind as we move on things and we decide things and move forward and we direct staff to do things, that things do change. But for us just to keep in mind the import of our decisions and then taking a step back and changing them and what that means for staff and our ability to do our work as a board. And I do still maintain that I think that what was just said a moment ago is important. Power dynamics play a huge part in all of this, and that I think that I almost feel like we probably need to start tracking the type of, we do this with substance abuse. I think we do it with sexual, I don't know if we do. Huh?
Sexual misconduct?
We do.
The overview of the enforcement activities.
It is on that overview. Thank you. I couldn't remember that graph. And that we also just keep mindful of that. Is there any public comment about the motion? I can't see if there's a hand going up. No? Okay. Hearing no more conversation, can we have a roll call vote, please?
Guaybadil? Yes. Kasuga?
Aye.
Erickson?
Aye.
Boo?
Aye.
Horn?
Aye.
Jones?
Aye.
Phillips?
Aye.
Motion passes.
And you had a second motion you wanted to entertain?
Well, I don't know how to phrase this one. I want us to move ahead as quickly as possible with 2960.1. I don't know why I can't remember that. So I'd like us to pick that up right away and give it some emphasis. I guess that wouldn't be till the next legislative session, right? But
well, the activity is different than the legislation.
Right.
So you're saying, if I'm hearing you correctly, you want us to take action to move forward with looking at the issues in 2960.1.
Right. That's my motion.
Is there a second to that motion? Yeah. Okay. Is there any board comment about that? I guess the question would be for staff in terms of timing of what would make sense to do that. I think if that's your question.
And in order for this to work well with us, it would have to be in the preceding months so that we could approve some final language at your November board meeting again. That way we are ready to get on a legislator's docket in January or before that. So that November board meeting would be hopefully the culmination of whatever stakeholder work, activities, discussions, and that's where you would approve that sort of language. And obviously having all the boards and public and professional organizations involved at that point. So.
And I think that a part of that, it sounds to me from the earlier conversation, would include working with the other boards as well. And sharing I think being able to take back the discussion here at this board meeting, what has been happening, I think that was captured from the earlier conversation. Yes, Ms. Sorick.
Ms. Jones, just to clarify, the provisions of 337 and 728 of the Business and Professions Code would impact the other three boards, but 2960.1 would just impact our board. So we could certainly invite stakeholders of our board, consumer groups, professional associations, to discuss and have healthy conversation about what that language looks like now, what it should look like, and then we could bring some language to the full board in November so that we could get on the calendar for next session.
2019.
And I do think that also, I think would suggest is the input from the legislative perspective, and language is really important, but also the wisdom of our enforcement work is really important and key on that one in terms of how we define it. And I think that Mr. Tomplay might also be able to be helpful in that in terms of what are those sticky cases that we weren't able to go forward on in terms of how we define. I think we could use some of our past experience to help guide us, perhaps. Dr. Phillips?
So what's the next step? I hear what the end of it is, but what's the next step in this whole process? Is it that it's going to go to the Outreach and Education Committee at their next meeting? Are we delegating something to staff to work on? What would you suggest, Ms. Sork?
I would suggest for the chair of the Policy and Advocacy Committee, perhaps, that we put this on the agenda for that meeting to have a substantive discussion on the language of 2960, not in terms of a legislative proposal yet, but just in terms of the language, and then we could bring that to the summer board meeting, August, for the board to again have another open dialogue about the language, and then we could refine it by the November meeting for consideration for next legislative session. Just procedurally a thought.
And Ms. Sork, I do think that would make sense, and I do think though there could be some interesting information because we have enough time. Well, we have some time to be able to also share that with an enforcement committee. I know your next meeting is the 2-day with those other pieces, and I do think that's a great opportunity for outreach and education, but then that means it's a discussion to maybe the full board before November maybe, or something, because I feel like the feedback that could be gotten in those particular committees might be helpful in fleshing out what we hear from stakeholders.
And obviously, we want to have appropriate outreach for purposes of stakeholder groups that we do want to get input from all the way along the way, so that we can work out whatever bugs there are in the system as early as possible. Okay.
May make it hard for the May meeting. You sure you mean May?
Akwebudu. Kasuga.
Aye.
Erickson. Fu. Horn.
Aye.
Jones.
Aye.
Phillips.
Aye.
Motion passes.
So the next item was item 15, but I kind of feel like, did you want to take that one, or do we want to hold that to another, given all the conversation about defining?
Well, since it's going to be part of the legislation we're going to move forward with, probably be most appropriate, I think, perhaps Ms. Burns would be the appropriate person to present.
Ms. Monterrubio.
Or Ms. Monterrubio. Yeah.
I don't even have that anyway.
So we're on item 15, and that was to review and consider draft therapy never includes sexual behavior brochure. A little bit of, well, do you want to talk about the background? Okay, so there's been some changes. I think this brochure initiated in late 1970s. There's been some changes over the years. Last time was in 2011. As you all know, we've been working with Medical Board and BBS to update the brochure. Each board consulted with subject matter experts, board members, for feedback. And we're now bringing that in front of you to take a look at and see the recommended changes that we've made. Would you like to go from page 1? I don't know how you want to take a look at these.
That'd be fine.
Okay.
Do we want to go through page by page?
While I it's not a recommendation to rush through this document because it is a lengthy document, but in consideration of the time, perhaps if board members have any amendments on any particular page, we'll just go not line by line, but just page by page, and if any members have proposed amendments to the draft, we can do that.
First of all, I want to say this is so much better. So whoever worked on it, really, really good. So, no. I don't know if I wrote this or you wrote this. So this would be introduction. There is on the third paragraph.
I'm sorry, Dr. Horn, are you on page 3 of the document?
Where
it says?
Yes, page 3.
Okay.
Introduction. So it's under introduction, third paragraph, and the 1, 2, 3, 4th line down. Is therapist scratched out and client put there, or did I do that? I'm sorry? I did it? No. Okay. All right. Let me get to what I did do.
The red highlights are, I'm sorry, I just lost the page.
That's right. One's the medical board.
And,
Yeah.
I think the blue are the
Yes.
behavioral sciences. And osteopathic medical board will review this draft after you all come to agreement with language. So, and then at the end, the Department of Consumer Affairs will convene all the recommended changes and then work from that draft.
Okay. So now I'm on page 5.
Oh, we're doing page by page, right? Not person by person.
No, I just did.
I think we're doing it page by page.
Oh, we are?
So I think we should go back to page 1.
Okay. Were there any changes on page 1?
I thought we were doing by people.
15. Okay, thanks. Because I just lost. I was on it and then
No changes on page 1?
Just in light of the board's motion just previously, on the first paragraph, the last line, do you need it to say sexual contact or sexual behavior? If that definition is being placed in 728? Is that correct?
Last line of that first paragraph there on page 1. Sexual contact with a client.
We can add the sexual contact or behavior. Is that what you're asking?
That's what I was asking, if it makes sense to add or sexual behavior since we've added it to 337 and 728.
So,
Ms. Marks, actually, on the first sentence and the second sentence, we have used sexual contact, and sexual behavior by themselves. So maybe we need to do that for every time we list it. I don't know, but just FYI.
but yeah, and this paragraph is talking about what's illegal and unethical, and sexual behavior is not necessarily illegal, but sexual contact is in California, and so I think maybe it was just sexual contact meant there.
First sentence and second sentence.
I think the last sentence is the lead. It's led in by the sentence before it. Right.
It's talking about the responsibility. I don't.
Right. Professional therapy never includes sexual contact. It also never includes inappropriate sexual suggestions, blah, blah, blah.
I know.
Yeah, we should say or sexual behavior there.
If we're gonna add it.
Yeah, or other, yeah, you're right. Do y'all see where that?
So you want to add sexual behavior to the last line and add sexual behavior.
Well, I think as Ms. Stark's pointing out,
Not
does
anywhere
that apply more to the disciplinary action, which does not necessarily apply to all the boards
What I thought we were getting
at this point? So,
Your job doing.
as opposed to the trigger. Okay, so then,
Okay.
I could be wrong.
okay.
So what are we saying? It is always the responsibility of the therapist to ensure that sexual contact or inappropriate sexual behavior.
No, we think that because that is more of the, what's the basis for discipline, then we should not yet include that as.
Okay.
Because of the preceding sentence.
We're talking about illegal and
Right.
it's your responsibility to ensure that that comes.
Because we're talking about being illegal. Okay.
Any other changes on page 1? Page 2? Page 3?
About page 2. And I guess it's the bottom of page 1. I just that the acknowledgments about the joint collective work of the boards. I think that might be important to state personally, and I think historical references are always great personally. But I just wanted to say because we've kept those on there in 2017. I don't know if there's a need to take that off now. But not necessarily super strong recommendation behind it. But I do think it is something to really acknowledge the joint efforts of the different boards.
I think we need to keep in mind, personally, what the object of this brochure is, and it's an informational brochure for consumers. I would agree with you that it's important for us to keep in mind the contributing agencies, but
Oh, it moved to the back. Okay, thank you. I thought I saw it somewhere before. Okay, thank you. Nature of the clients, but I think it's important to know folks are always looking on all ends.
On page 16, publishing information, it talks about the 3 boards working
I
together.
thought it was there, and then Ms. Sork just told me. Thank you.
It's hard when you strike through. Is it gone, or is it moved?
Any other changes to page 2? Page 3?
I have one item. It's the 3rd paragraph, and I think it's the 2nd sentence. It's not reading right to me. If I think this is how it reads. However, a therapist who accepts or encourages the expression of these feelings through sexual behavior with the client or tells a client that sexual involvement is part of therapy is illegal.
Right.
To me, that, however, a patient who accepts or encourages the expression of these feelings or tells them that it's part of therapy is illegal.
Who
There's
accepts
something-
or encourages the expression of these feelings.
Yeah, there's
Therapist
something
who
that's,
accepts or encourages.
maybe it's that middle portion that tells a
Yeah.
client is illegal.
Right.
It's the expression that's
Because you're referring to the expression of these.
right. But then when you have that part in the middle, it just it doesn't seem to quite follow to
Yeah.
me.
The expression.
Maybe you could put that middle part in parentheses or something. Because you're saying the expression of these feelings through sexual behavior with the client is illegal, unethical, and violates. That's what you're saying.
Right, but then you said or tells a client that it's in part of therapy.
That's illegal. Well,
Maybe,
yeah.
but it's just
Right.
grammatically it's funky. So
Yeah.
it might just be one of those things that we don't necessarily need to wordsmith now, and at the end, depending on what you do, you can have the a delegation for grammatical purposes.
Yeah, that's a good idea.
Okay, good.
Because we'll get too much in the wordsmithing, as I can do.
Any other changes to page 3? Or comments? Page 4?
So, real quickly, we're changing it from patient's rights to client rights, is my understanding.
Yes.
I'm moving that section up, and so just for conformity, section 3, the 337 section that we just talked about legislation still refers to it as patient rights, and so I wonder if we need to align that part of the code to our proposed edits to client.
I'd like to, are we on page 4 now?
Page 4, yes.
Okay. The bullet, let's see, 1, 2, 3, bullet 4, ask questions about your therapy. I'd like to add or other services you're receiving. It's not just I know the brochure's about therapy, but I think clients have a right to ask questions about any service they're receiving from a.
Or other services you're receiving.
Yeah, or other services from whatever, I don't know. Whatever, that's just, y'all work it out.
From other services from your provider.
I just want to highlight they should ask questions about anything.
Okay. Any other changes to page 4? Page 5?
I have a page 5
Okay.
change, and this is near the top of the page. It's the 1, 2, 3, 4, 5th bullet. Receive a second opinion at any time about your therapy or your therapist's methods.
Okay. Anything else?
I have another one on the same page. Yeah. Let me see what that is. It's after the crossed out, it's under warning signs, and after the crossed out, another warning sign is special treatment by the therapist. So it's the first bullet, inviting a client to lunch, dinner, or other social, I would say, or professional activities instead of and.
Really quick. One addition.
Okay.
Huh?
Once you're done.
Okay. And then bullet point number 3, changing the office's business practices. For example, scheduling late appointments, I would say when no one is around instead of so no one is around. That's it for me on that.
Okay. Anything else on page 5?
I have a quick one on page 4, and it's just to be consistent with our legislative proposal to have the second sentence of the sexual behavior about the not precluding the appropriate therapeutic relationship language.
Okay. Anything else on page 4 or 5? Page 6?
About page 5, I'm of a mixed opinion on this. Honestly, that's why I'm hesitating slightly. I don't. Some of the ones that are stricken, I don't know if they should be stricken. In terms of the first warning signs, I like the change about unwanted physical contact, but the third one, I'm just, I guess, reflecting on some enforcement cases that I recall seeing. I don't know if I,
Are you talking about the one that says sitting too close?
no, discussing the therapist's.
Sex life.
Oh, sex, okay.
I feel like I don't feel comfortable striking that one out. And quite frankly, the sitting too close and initiating hugging, I know that is what unwanted physical contact is. I almost feel like redundancy might work really well in this case. I just thinking about certain cases.
I would actually take out excessively, leave that taken out, and just say discussing the therapist's sex life.
I would agree with that.
In the second set of goals, the fourth one, you want to include it in there?
Oh, there you go. Yeah.
I think that.
Yeah. Okay.
Why it was stricken.
Although, quite frankly, again, I will just say redundancy might not be a bad thing, but okay. I got it.
I do want to add, what we're talking about here is a pattern of behavior, and these are warning signs that something may be going wrong. The fact that any of these happen doesn't necessarily mean that they've strayed in. They may have had a boundary violation, but they haven't necessarily groomed you for sexual behavior. It's a constellation of behaviors. So these are warning signs. These are not prohibited behaviors. They could be within the ambit of prohibited behaviors, but I don't want to. You know, as a therapist, there's exceptions to every rule. There's the patient you've seen for 24 years, and they say "I love you" at the end of therapy, and you say "I love you too," and it's clearly not understood as being a sexual or romantic thing. That to me is not inappropriate. The kiss on the cheek that was mentioned before, I can understand how in the wrong context that could be a terrible thing. I don't know that I've ever kissed a client, but I can understand what Ms. Winkleman's saying. So I just want to think, when we're talking about these warning signs and these things, we're not talking about things that are just black and white incorrect behavior.
Although, Dr. Phillips, I would say it's not a problem until it is. And I would say that I don't know if it's always so black and white, quite honestly. And when I think about, again, these are warning signs, so you may miss the sign or whatever, but if you are a consumer reading this, you need to be informed and know, no, it isn't. There could be a problem with someone saying,
that's what I'm saying.
and so I think that although I might agree that it probably is never appropriate, perhaps, I don't think that's a professional way to necessarily respond, but I think that is where I think it's not a problem till it's not. So I think that's, as we look at this list, we should keep that in mind as well, I think.
So
That's why they'd be warning signs. The constellation of behavior may be problematic, but it has to be understood in the context of the therapeutic relationship and the purpose. And what I'm really saying is, these in and of themselves are not a list of prohibited contact.
Well, that it says warning signs. It
Right.
doesn't say
That's all I'm saying is emphasizing the fact it's warning signs.
So, Ms. Jones, did you want us to leave in number 3, discussing the therapist's sex life, and just taking out the word excessively?
I personally would, but I could see that it might be redundant, but
And I don't know that there'd ever be a case where discussing your own sex life would be appropriate.
Well, all of these are warning signs, so
Right.
you've got it. I think you do have the same thing in 2 places. Yeah. So, confiding in a patient or a client, for example, about the therapist's love life, work problems, loneliness, marital problems, etc. That says to me the same thing as discussing the therapist's sex life or relationships, and it's clearer to me that this is. So I'm kind of.
I could go either way. I do think saying it twice could be good, because that's confiding in them about that. Discussing it, it's not I just don't think it should be, but.
That's fine.
I'm good.
Twice. Yeah.
Well, remember that this is a joint project.
Right.
So as a joint project, we can take our suggested changes back to the group. That doesn't necessarily mean that's going to be what ultimately happens.
Yeah.
Because quite honestly, that could also be relying on a client for personal and emotional support as well. But I think there's some things we should call on out.
You're right.
Yeah.
Yeah.
Any other changes to page 5? Page 6.
See, and I have to get closer.
We're suggesting it could.
I don't want to keep it in, but if we're keeping it in,
Keeping
but
what?
if
Okay.
bulletproof 3.
Which are we keeping in?
So bullet 3 we're keeping in and presenting it to the.
Except taking out
Correct.
excessively.
But I have it,
we're-
say that it's repetitive on purpose.
So it may not
Um,
stay, but we'll leave it in for now.
But we're taking out excessively.
Yes.
Bullet point.
That's what I
Yes.
have.
Got it.
Any changes to page 6?
Intimidated or threatened by a therapist's behavior, and it's okay that it's been stricken out. I can understand that, but I think that we're talking about that on page 6, common reactions to sexual misconduct by a therapist, and maybe feeling intimidated or threatened is one of the common reactions, and maybe that should be added.
That's a good idea.
To the next page.
Any other changes to page 6? Page 7. Page 8. Okay, sure.
Ms. Marks pointed out that some of these behaviors may not be illegal, and here under reporting the therapist, we state that it is illegal. Is that okay to leave it that way?
Where, I'm sorry.
Page 6, what can you do? The heading, report the therapist. What happened to you, it's underlined, is illegal and unethical. Am I on page 7 by mistake? I'm on the wrong page.
You're on page 7.
Page 7, excuse me. Long day.
Wouldn't it be more appropriate to say may be illegal or unethical?
Maybe, yeah.
I think that is.
I was trying to pick up on your point that it's not necessarily some behavior or may not be illegal.
I think it may be a basis for discipline under statute. I think that's kind of what the difference was of what we were talking about on page 1, because I think there we were talking specifically about whether or not it was misconduct, I think. Yeah, I think there we were talking about whether or not we've included sexual behavior specifically statutorily in basis for discipline, and I think here you're talking about generally several types of different behaviors, some of which might be sexual misconduct and some of which might be boundary violations, but even the boundary violations would be a basis for discipline
But it
under
doesn't,
the statute.
it doesn't mean that it is necessarily.
Correct. So maybe it,
Maybe.
yeah.
So we're gonna say may be illegal or unethical? Okay.
Any other changes to page 7? Page 8.
Sorry, I think we'll just need to remember to add in osteo, right? Oh, osteo is
Yes,
already
on
in
the
there,
next
so.
page.
Page 8.
Was it 1, 2, 3, so that makes it 4.
Mm-hmm.
So on page 7, do we need to change a 3 to a 4?
Yeah. It should say on page 7, it should say in California there are 4 boards.
you see that, Sandra?
We made the change.
Yep.
Okay.
Anything else on page 8? Page 9. Page.
I just have a question. Given, I mean, I feel like the language is good. I feel like if there is an opportunity to, I don't know what the thought might be, Miss Marks, because maybe it's too much. But that third paragraph where we start to actually list information, we're telling people how to submit. I think it just encourage letting people know there's no repercussions, like there's no I don't know the word I'm looking for.
Adverse consequences?
Yeah, I'm thinking given the whole conversation in this current environment about this notion about whistleblowers and protection of people, I feel like there might be a need just to let people know you can do this. And I think the question yesterday someone asked about, well, do people know they can actually do it? There's no fee or whatever. I don't know if there's a way to make that a little bit more straightforward, and maybe I'm overthinking. I don't have suggested language though.
Ms. Marks, maybe I could ask you a question. If someone were to maliciously file a complaint with the board, is that actionable in any way?
I think you'd be asking about something that would happen in a civil proceeding.
Okay.
Whether or not the therapist could file a complaint for malicious, civil complaint for the filing of a malicious administrative complaint?
Mm-hmm.
I don't know.
Okay.
And Dr. Erickson just gave me some language, because I feel like we've heard this before from Ms. Monterrubio about, we do get, sometimes there are frivolous, I think it's a term that you've used before, but without retaliation, I think is the language some way to be able to tell people can submit a complaint, because if they're intimidated and afraid and they have those feelings, I just feel like there's a way to communicate that you can do this without fear of something.
We don't have that exact language in here, but starting on page 13, frequently asked questions. We can look to put a question there, because it talks a lot about can I file a complaint and civil lawsuits and things of that nature. So you want us to specifically talk about there would be no retaliation?
I think you
for
have
filing.
to say on the board's part, because we don't know what the potential respondent.
Well, that's why I was saying putting it there. You can submit your complaint to these organizations without retaliation. You can submit to a state agency without being afraid to in any way be penalized by the therapist. That's really.
We can't say that. We can't say that. We can't stop people from engaging in behavior, even if it's inappropriate behavior.
No, I'm talking about you can't stop the behavior, but you can file the complaint. There's not if I am seeing a therapist and I go and file a complaint, I'm not in trouble for filing a complaint, am I, as a patient?
You wouldn't be in trouble with us, but we don't want to say you would be immune from getting sued in a civil suit.
I got what you're saying.
So I wouldn't want to say no harm, no foul. I mean, we want to encourage people to file a complaint with us, and there would be no ramifications from our agency to the consumer for filing that complaint. But we wouldn't want to say you're untouchable if you move forward, because
we don't know.
We don't know. I mean, someone could always file a defamation suit or goodness knows what other ramifications the psychologist might use. And I wouldn't want to give a false impression in our brochure that you're completely untouchable. At least from our perspective, you're untouchable, but
I think, Ms. Jones,
that makes sense. Or?
It does make sense.
Okay.
What I discussed several meetings ago was that sometimes consumers will call us and say, well, I reach an agreement with my therapist and now I can't file a complaint. And we let them know you can still file a complaint even if you reach some type of settlement with your therapist. So maybe that's what you're thinking. I'm not quite sure, but I'm not comfortable putting in language about there will be no retribution when we don't really know from the therapist side.
No, I appreciate that distinction there, and I'm just thinking about given the conversations over the last couple of meetings about people saying that people aren't filing, they don't feel comfortable filing, I was trying to figure out whatever that language could be in print to a consumer that they would feel, I mean, there's a consequence for everything, I suppose, in life, but I feel like in terms of them feeling that they don't have to, any consumer in the state of California has the ability to submit a complaint. And I feel like that is, I guess maybe it's already here. I just wanted to say that out loud. I feel like that when I think about we just went through that list of how someone might feel as someone who's experienced that. What is the best language to really drive home the point that they could file a complaint? But you're right, legally we can't state that. That's not true.
May not be true, yeah.
May
We
not
don't-
be. I mean,
yeah.
it may not.
Yeah. So what page are we on now?
Page 9.
So I have no change.
Okay.
That's a good thought.
Any other changes or comments to page 9? Page 10. And page 11. Page 12. Page 13.
I had suggested, what page are we on now?
Page 13.
Okay, I had a suggestion under the section, it used to be called Finding a Therapist, where we say, ask someone you know, and I was going to add the words "and trust" for a referral. So that they use some discernment and don't just ask anybody they know.
Sure. Any other changes to page 13? Page 14.
And so my comment about trying to put the other language somewhere else, I know we struck through the language about retaliation, and I feel like it makes sense given the way it was worded. I would just want to say, can we just ask other boards about this in terms of this language? I just would be interested to see their feeling on that one.
Yeah, we'll consult with the other 3 boards.
I really like your questions and answers, though. I really like the way you've answered them in this brochure. Or y'all have.
Okay. Is there any other changes to 14 or comments? Page 15 and 16.
On 16, oh gosh, now where have I gone? On 16, we didn't include the osteopathic board, so if we could include them as well.
This is just more a question. On page 16, I think, Ms. Jones, you mentioned earlier the moving of the publishing of information. This language here is edited slightly where it doesn't mention that then Senator Diane Watson sort of pulled together this group. And so just calling that to your attention to see if that's something you wanted to carry over into this section as well, or if the language, because there's 2 different languages, and I mentioned the historical perspective.
I noticed that, and I was of a mixed opinion on that one, but I figured I liked the other part on there, but I do think it is important. Like we have the little footnotes in the publication, but I'm not wedded to promoting that necessarily, but I do think it is important.
I certainly share that sentiment as well.
I'm putting the history now, yeah.
or something, maybe we can either add it as a frequently asked question or add it under what you can do, like that it's free of charge or that there's no cost to the.
Sadly, Dr. Kusuga, that was this morning that we had
was
the
this morning.
conversation.
I thought it was like yesterday. Yes, it's been a long day. Yes.
Yeah, that's true.
We put in there you don't need a legal representation, right?
Another possibility, do we want under the FAQs to say something about, will I have to face my therapist in a civil or administrative proceeding? Answer no. Do people have fears about that, I wonder?
We don't know the answer to that question. They may have to be a witness in the proceeding if they want it to go forward.
Oh.
I'm sorry, what was?
Yeah, we missed that.
We
We're
missed that.
sorry.
What was your comment, Dr. Erickson? Or your question?
I think people have a fear that they're, of all kinds of things, that they're going to be exposed or confronted or have to face the therapist in an administrative proceeding. And I had thought that we don't do that, but we may require that in order to proceed.
That they may be called as a witness, so, and we don't take anonymous complaints. Well, we do, but they're hard to investigate, so there is definitely a chance that they would be called as a witness.
That's not going to work as a reassuring answer to a question. Thanks.
And I think that we don't want to give them obviously misinformation. They are taking risks in doing this. They are going to expose information about themselves to public scrutiny in the context of the proceedings. So I think it's better if we stay away from it.
And that's why I did like the response that previously was there about the retaliation question, which is why it said it'd be good to see what other people say. But I feel like that does answer the question where it does state that it's possible that there could be some exposure.
That's in there.
Where is it? You said it's in there.
This is good.
Yeah. Where are you speaking, Dr. Horn, that it's in there?
I said y'all already have that in there earlier.
About the retaliation?
No, it's not at all about retaliation. It's about you might be called on as a witness and can I talk to my therapist? No, we encourage you not to, you know, blah, 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 but you may be called as a... That's way early in this brochure, I think. I don't think we're recommending a change there or anything.
No, I think it's fine.
Yeah, it's fine, and you're exactly right. We can't. We don't know. Yeah.
Any other changes?
Is there any other board comment? I take it there's some public comment. Come on, Dr. Winkleman.
Hi, Dr. Elizabeth Winkham with California Psychological Association. I just have a 1-minute comment. One is just to say I appreciate all the work of the board and the staff on updating this. I think it is really important and timely, and that this is an important brochure for our consumers. And the other is just I wanted to clarify a comment that I said before because 2 people have referred to it since then. The example that I gave was if a client kisses you upon termination of years-long therapy, say a middle-aged woman that I have worked with for 5 years gives me a hug and a kiss on the cheek at the last session, the example had said you would need to stop the behavior and inform them why it cannot happen again. And that in some circumstances, if a client kisses you, such as that, I don't think it would be very helpful, therapeutic, or needed to stop them and inform them. So I just wanted to clarify that because I don't want to go down with a misunderstood comment of I'm kissing patients goodbye, So
In fact,
that was
shaming to the patient.
excuse. Oh yes, absolutely. If you say, oh, you can't, so it could be really not therapeutic. And I just wanted to clarify the example was a patient kisses you in a non-sexual, given the totality of the circumstances, not inappropriate manner. So just point of clarification and thank you for the work, excellent work on this brochure.
Do we need some kind of
Out of motion? What would the motion be?
I move that we accept the changes as listed and commented during this meeting to the brochure to share with the osteopathic board,
As well as DCA.
as well as DCA and the other two boards there.
Second.
Is there any discussion of the motion on the board's part? Any public comment? Okay.
Okwebadu? Kasuga?
Aye.
Erickson?
Aye.
Wu?
Aye.
Horn?
Aye.
Jones?
Aye.
Phillips?
Aye.
Motion passes.
Really good.
You did a marvelous job.
That's cool.
Okay. So, so we're going to take a 5-minute break, really a 5-minute break, 4:15, and we're going to finish a policy and advocacy quickly, as I've been instructed by Dr. Phillips. We're on 20B, and this is the review and consideration of the board recommended items of legislation. AB 244, 710, and 572 are all dead. They're no longer items that we're watching. Does anyone have any questions about that? So it's all for informational purposes. No action is requested at this time.
Absolutely.
The next section is number 2 is watch bills, and these were all the watch bills that we were watching over this past year. Some of them have moved to 2-year bills, and some of them have also died. But we provided this just for our information, and we'll get a revised version at our next meeting because today's a deadline to submit legislation, and the committee will actually meet. So there really will be a report back to the full group. This is just a report back out. Yes, ma'am. Dr. Horn.
Thank you. Can I just ask a question? So if I just want to make sure I'm reading this right, and by the way, I really like this new way of doing it. It's much easier to understand. But if I look at AB 44.
Can you tell me what the number is?
On the watch bills?
AB 44.
AB 44, it's the second one. So you've got chaptered, bolded, and that means
That bill was signed.
then, but we're still watching it?
No, this is the remaining from last year. So everything that we watched last year. So as of next meeting, now that today's the last day to introduce bills, we will go through and remove chaptered and dead bills.
Oh, okay.
It'll be a new list from now on forward.
All right, thanks.
It's the end of the year recap so that you know everything that happened to those bills that we were watching. And again, the watch bills are not items that we actually had a board position on.
Right. Thank you.
Are there any board comments or questions about this information? Again, just echoing, it's a wonderful format. Mr. Glassfiegel.
Pleasure.
Is there any public comment about items 1 and 2? Seeing none, that's the end of the Policy and Advocacy Committee.
That was fast.
Les, thank you very much.
Ms. Jones, at the November board meeting, Dr. Winkleman did bring to the board's attention that there was going to be a piece of legislation on telehealth reimbursement, and I think I mentioned during a break that once that bill had a bill number, that we would add it to the board's agenda for review and consideration. So I just want to mention that we will make sure to, if you get a bill number today or sometime this week, if you were assigned a bill number, if you can let us know so we can make sure that's placed on the Policy and Advocacy Committee agenda, and then it'll come back to the full board in May. So I just wanted to mention that because it did come up at the November meeting.
Okay. Item number 21 on the agenda, which is legislative items for a future meeting. Again, these are suggested items from members of the public or from board members, but we can't discuss the substance of those items.
I know that the Policy and Advocacy Committee will be meeting in March, but I do think, given the comments earlier about what is the board doing about Me Too and the issue of sexual behavior and contact in the environment currently, I think that perhaps we need, as we cast our net wide for watch bills, we might want to include those as well.
I was asked by the Center for Judicial Excellence to watch AB 2044 before they left for today. So I will add it to the watch list.
Okay.
It's a bill relating to prioritizing child safety in custody proceedings.
Okay. Anything else? Okay. Item number 22, we're going to move over to the May meeting. Item number 20. Are we moving 23? Oh, can we do 23?
So item number 23 is our regulatory update. Mr. Glass-Steagall, can you just provide that? It's a very brief update.
Absolutely. The following regulatory packages are pending the start of the initial review stage. That's the psychological assistant regulatory package, the standards of practice for telehealth, and the retired license, renewal of expired license, and psychologist fees regulatory package. So they're all within the initial discussion between the board and legal counsel before it begins its process through the department review, which is the 6 to 8 month review process.
Dr. Phillips, that's the only thing. It's no action to be taken for the board, but that is just the update for informational purposes.
Thank you both.
Is there any public comment about that at all, I guess?
Okay. So item number 24 is the outreach update. Ms. Bernal was not able to join us because of personal circumstances, so we will be holding that over till the May meeting. Item number 25 involves me. It's the President's Report. In your package, you'll find the 2018 meeting calendar and the different locations, proposed locations for the meetings. Is there anything particular you want to mention there? Oh, right. So we have, in terms of committee updates, we do have one update that we wanted to mention, which is the EPPP 2 task force has been formed. It will be chaired by Dr. Kasuga. It will also have the inclusion of Mr. Fu. I was going to call you Dr. Fu, but Mr. Fu. Those will be the two representatives from the Board of Psychology. The following people will be members of the committee or the task force, have agreed to be members of the task force. Dr. Andrew Harlem from the California Institute of Integral Studies, Dr. Renee Pulati, who's the Executive Director of KPIC, Dr. Susie McGraw from KPIC faculty, and Dr. Paul Marcial, the CPA president, Crystal Faith, oh my goodness, Gahalak, from the chair of the California Psychology Association of Graduate Students, Catherine Cruiser, who is the CPAG's chair-elect, Sherry Sadler, also from CPAGS, who represents Cal Southern University, Brian Knoll, also from CPAGS, school representative for California Lutheran University, Anushri Bellur, the CPAG's representative from the Chicago School of Professional Psychology, and Alejandro Ojeda Black, who is the school representative for UC Berkeley. Amy Welch-Gandy from the Office of Professional Examination Services of the Department of Consumer Affairs will be a member of the task force. Dr. Alette Coble-Temple, and I apologize to anybody for pronunciations here, from JFK University, faculty member. William Bloxham from JFK University, who's a student there. Dr. Jay Finkelman from the Chicago School of Professional Psychology. He's in the Industrial Organizational section. Dr. Sherry Johnson, the Director of Clinical Training at UC Berkeley. Dr. Cindy Yee Bradbury, the Director of Clinical Training at UCLA. And Dr. Gilbert Newman from the Wright Institute. It's the current constitution of the committee. Have I missed anybody? Yep. Okay. Is there any board comment on the president's report? Okay, I see that there's public. Okay, thank you very much. Dr. Lindecrow?
Just a question. Just a question. I noticed in the list there were quite a few students on the group. I guess I'm not clear on who was invited to participate. We did receive a letter, and so we recommended one person. Would there be an opportunity to have more than one person? Or I see there were I see both our CPAG's chair and chair-elect are on the group, and I was not aware that they received an invitation to be on the group. So could someone just kind of fill me in on how that was done, the process?
The board reached out to training programs. We reached out to student programs. We reached out to schools, and we asked them to select representatives from the organization to be present. This will be a meeting that will be publicly agendized, so it'll be a Bagley-Keene Open Meeting Act meeting where anyone from any other organization can come and participate and be part of the discussion. These are the standing members of the committee that have volunteered to represent their organization. So this is how we came up with the list that we did. We reached out to the organizations.
Okay.
They sent these.
I guess I misunderstood maybe. I thought you wanted one person. And we might have recommended more than one. I'm just curious why two from CPAGs. Or if you just ask for volunteers, then I can understand that they might have volunteered. I'm not sure there are any early career psychologists on that committee necessarily.
There's 6 representatives from CPAGs.
Yes, there are a lot, and I'm not sure how that really happened. So
it could be because they're representing different schools, and they're representing those interests.
they're not. If they're representing CPAGs, they're representing the California Psychological Association of the Graduate Student Organization. So I guess my question would be: are there still is there still room for anyone else to be added to the committee? Because we might have recommended, for example, someone from our Division of Education and Training. I thought you were requesting one representative from CPA. Maybe I misread the letter. I don't know.
Numbers wise, because we are going to be paying per diem and travel reimbursement for these folks, so I don't want to cast the net a whole lot wider, and this will be a publicly open process, so there will be opportunity for input from any organization if there are additional people that would like to provide input.
I'm just curious, did you look at the balance of people, or did you just take whoever volunteered?
We reached out and asked for a representative, and I don't know if it was because some people weren't available for the 3 meetings that we've reached out to, because I know for one meeting, for example, we have 13 members that are able to attend of the 19. So we will have a quorum of the 19 attend. But that could have gone into the consideration of having more than one person from an organization come because of availability for the 3 meetings. Because I think the hope is that we just have 3 meetings and we can, the committee can go through the regulation changes that will need to be made in order for the 2020 implementation date, and then the policy considerations like the eligibility to sit for the exam. Currently, we determine eligibility to sit for the EPPP, but the Association for State and Provincial Psychology Boards has offered to provide eligibility at a certain stage in the game, depending on where someone is in their hours of training or pre or post-doc. So, I mean, those are just a couple of Cliff Notes versions of issues that are going to be dealt with, but then that'll be presented to the board.
Okay, thank you.
Hi.
Hi.
Dr. Schaefer. Division 2 on education and training is comprised of folks from academia and training sites throughout California. And you've had a designee, me for probably 10 years or whatever long I've been here, and a designee coming to these board meetings for much longer than that. Given that's the EPPP, it probably would be nice if the board would consider having someone, not myself, I would not want to be the one, but someone from one of the academic institutions or the director, rather our chair at present, or someone from the board of Division 2 to be participating. It kind of seems to me a little bit like an obvious thing and, kind of a hole for not someone from that board not to be involved, since it is the EPPP.
Did we specifically reach out to Division 2?
I go to the board meetings, it wasn't on the agenda, and I get all the emails coming through, so.
It is my understanding we did reach out to Division 2, and I think I was specific about.
Who did you reach out to, do you know?
I didn't myself, but I can follow up with staff and get back to you.
Sure, and I can send a text to our chair, who would bring that up at the board meeting, so it wasn't, and I go all the board meetings. But if you haven't reached out, would you consider that as an option?
We have reached out.
You have reached out?
We have reached out.
But I will follow up and make sure we contact the right individual.
Yeah, that would be, okay, that's okay.
Okay, so that concludes the President's report. I think the only remaining agenda item, maybe we can do recommendation for agenda items for future board meetings first. Why don't we do recommendations for future agenda items for board meetings? Again, no comments, just suggestions for agenda. Any suggestions from the board itself as to agenda items? Yes, ma'am.
And maybe something will come out more clearly after the enforcement committee, but I do think there might be a useful presentation about child custody evaluation at the board meeting. And I think that child custody evaluation as a meeting item in the future. And I also would like to see us talk about I'll come back to it. Sorry, I can't find my note.
Dr. Lindercrow?
You're asking for items, future.
Agenda items, yeah. We'll come back.
I actually did have the other one. Sorry, before we go to public comment. DCA's prioritization guidelines, I just wanted to follow up on what that was and to talk about how we're doing that. I'm sure there's a reason we're doing that. I don't know if we're doing it as part of our strategic plan, but just to follow up on that earlier item that came up from public comment.
Yes, ma'am? My apologies.
No worries.
Sorry. I didn't bring my notes with me, so this isn't going to come out too well. And it may go to a committee first. But I'd like us to focus. I think this would come to outreach and education first. So maybe I'll just bring it up there. Never mind. Just thinking out loud here.
Yeah.
So glad we all could help.
And one more, I had my notes too, I had to flip. I just think that, so it's a statement and it's kind of a thought. The licensing committee process about stakeholder engagement and piece, I feel like that documenting that in some kind of way is important. And I don't know, like I know we talked about this visual, I think about Dr. Harlem, a pictorial kind of description. But I also feel like each committee should, I think at the next meetings, think about data needs and how could we use surveys? Because I think that when Ms. Sorek said yesterday about the surveys influencing and informing us about what the needs are out there, I think that if every committee is thinking about ways we could use that strategy, we could learn a lot from the successful strategy that licensing committee did. And that is it, really.
Okay. Dr. Linda Crow.
Thank you. There is one item that we are receiving more and more questions about, and I would like to just put it on the radar. A couple of years ago at your meeting in Berkeley, or whenever that was, you had a presentation from ASPPB about the Psi Pact, which has to do with mobility of licensure. And I don't believe that that has come up since. And given the fact that many jurisdictions are beginning to introduce legislation to enter into the Psi Pact, I would just like to have at some point on the agenda a conversation about what this board's perspective is on the Psi Pact and whether or not you have entertained the idea of California joining the ranks of Psi Pact.
We did actually, when Psi Pact was originally proposed, we did provide comments to ASPPB
Yes.
Based on board consensus as to reservations we had about it. And in looking at Psi Pact as it exists now, those reservations have not been addressed. We can certainly put it again on the next agenda, but I don't know that, and we've got a different constitution of the board, so they may feel differently. But we have addressed it, and at this point, based on what's happened so far at the board, we haven't expressed an interest in being part of Psi Pact.
You have not expressed an interest.
We love the concept of Psi Pact.
Yes.
But the actual mechanics of it would be very difficult in the state of California.
Dr. Phillips, I don't know if it's appropriate for us to discuss
sorry.
at this point in time. This is an item for future agenda item, and I think that it should be on an agenda.
Right. I think it would be helpful to maybe revisit that and maybe for us to learn again what the board's perspective is, since there is a much increased attention to the Psi Pact, especially it's discussed in the same breath as the EPPP too often, and so it would be helpful, I think, for the public and for the discipline to hear again what the board's perspective might be on that. Thank you.
And I apologize for commenting on that. It's just I was trying to give you the information that you were seeking. Okay, with that in mind, the final item on the agenda is the board election. And for that purpose, I'm going to turn,
You mentioned child custody for our next board meeting. What exactly would you like for that?
Not for our next meeting, for a future meeting. I think that the whole idea of I know, and then maybe this will come out in the enforcement committee report. When we were in Southern California last year, I know we had some questions about letters and all that stuff. Just a recap. So it'll be that way, but I feel like I just want to make sure that it gets on the agenda at some point, and maybe it'll come back through the enforcement committee report. But I think that there were some questions about that process that came up during the public comments in, what year is this? 2017 maybe, in wherever we were in Southern California. In Ontario. I was like somewhere in the IE in Ontario. And I know that at that time, at the end of that meeting, we talked about agendizing something future. And so I just wanted to say that one more time.
Okay, because on the agenda for the enforcement committee, we do have closure letters, acknowledgement letters for all of our complaints, not just child custody.
Got it.
And child custody folks have already been given the item that listed how we process those type of complaints. The board was given that as well, I believe, when we were in Berkeley. So I just wanted to be clear as to what exactly you were requesting. But hopefully this meeting in March, the enforcement committee will be looking at all of the closure letters for all of the complaints.
And thank you for asking for clarification, Ms. Monterrubio. I'm wondering also if, and this came up, I think, during a public comment or something during this meeting here. I think it would be interesting as an informational presentation, perhaps, to understand the reach of child custody evaluations. I know that it came up in terms of different court settings. Where is it happening, and where are our members, our licensees participating? It would just be good to be able to, and maybe it comes through with the enforcement report, but I feel like just to hear from staff where we and how we are serving that licensed population, it would be important, I think.
Okay.
Just so that I just have a touchstone or something.
Okay, thank you.
So I'm now going to turn the meeting over to Ms. Marks for purposes of the election.
Thank you, Dr. Phillips. I think in the past, the way we've operated the election of officers for this board is to start with the chair and to take nominations for the officer of the chair. And I'm sorry, president, sorry, president. And nominations do not need a second. You can second them, but there is not necessary. I think what we've done before is take all the nominations and then conduct a vote, and then we can move to vice president. If the board wishes something different, you can let me know.
May I ask a question? May I ask a question before we start the process? The question is, do we want to, I'm asking the board, do we want to take volunteers for different offices? That's just a question.
Do you want to take volunteers? So can somebody nominate themselves, in other words? Ask if just generally who is interested. Is that what you're saying before you take nominations? I don't see why not. Ms. Jones?
Actually, I guess my question is similar to Mr. Clay-Badu's, kind of, but not exactly. I just want to ask in terms of the process, and I feel like I try to be very careful about the Open Meeting Act, of course. And I don't know if we have a forum to get to that point of knowing who is interested and who wants to run, or not run, but who wants to be selected for that position. And so I just want us to, and I feel like this is probably the best point in the meeting to make the comments. I feel like I know that as a board, which is now totally reconstituted in a lot of ways than it was a few years ago, there was some conversation, and I don't know if it's part of our administrative document or not, and how our processes, there was a lot of conversation about how it's important to have a public member and a licensed member, and a licensed member and a public member serve in these roles. And so I just wanted to, I don't know, I don't have a dog in the race or whatever, as they say, but I feel like that, I think that it is important for us to keep that in mind. I think in terms of where we're trying to be. And I feel like the other thing that I just feel like it's important for people that are the newer members, I feel like when I was thinking about what the role of the president or chair or the vice president is, it's not necessarily based on competency of the field. We really are needing someone who can facilitate, who can be prepared, who can communicate and be professional. And so I think this notion of people feeling though they have to be here for a while should be dissuaded. I mean, like you shouldn't be dissuaded from wanting to do that. So this whole idea of knowing who wants to run. Also, we all get appointed usually for a 4-year term. Some people for less if you have an unexpired term. I think to be able to share the opportunity of leadership is important. I think each of us is available or is competent, is professional enough to serve in the role of chair. So I just wanted to say that as a set the stage kind of, because we don't have a forum unless I'm mistaken. I don't know if we can call people outside of the meeting to ask if they're interested or not. And I want to make sure that I'm in compliance personally on that. But I feel like I don't know if we have that format. And I know that it isn't, I know that at one point a board member talked about if you're vice president, you should automatically be president. I don't think we felt comfortable with that. And I don't either necessarily. But I do think that I hope that we would just keep that in mind in terms of the spirit of the group, that, you know, at some point it doesn't have to be just one particular type of person or a personality. And personally, I am, and I remember when I ran initially, or not ran, when I was nominated to be vice chair, the person at the time said, well, I'll give my seat over. And I'm like, that's not really how it should go either. Because it's not someone's seat to be given or not. You know, I think that we as a group can be led by each other. And so for that reason, I am not interested in either being vice president or president. But I also do think that we should make sure that we think about diversity in a whole bunch of different ways. We've had, since I've been on the board, a male president, no offense, gentlemen, but I just think in terms of who we represent, it doesn't have to be, and it's only been a licensed member since I've been on the board for 6 years. So I will just say that I just wanted to state those those comments in a way where I think that where one in the audience might have seen it be some challenges in the past, I don't think that's coming from a place of challenge at all. It really is a point for, I think we all should be encouraged and empowered if we want to be in the leadership role. So I just think that any of us, all of us, can be in that role. So I just wanted to say that, Ms. Marks, and ask for your guidance on how, moving forward, folks would be able to indicate their interests outside of, I guess, perhaps self-nomination at the day of which we're electing officers.
Thank you, Ms. Jones. The election of officers, I would say, is a matter within the jurisdiction of board, and I think the board members need to be mindful of any Open Meetings Act violations that occur with discussions about election of officers, just as anything else. So, if we've talked about the hub and the spoke potential for violating, we've talked about the chain or serial potential for violation. So I think the board members always have to be mindful of that. I can tell you that there are other boards who operate a little bit differently. They'll have a selection committee, so they get two people who the committee meets and they go over who they think would be appropriate officers, and they present a slate. So there's that model as well. I don't think this board has done it. I think sometimes it's with the larger boards where there are more people. So I'm not sure if that helps you at all, but I do. I think the boards do need to be mindful. I will say I'm not sure. I think Dr. Horn was on the board at the time, but before Ms. Sark was executive officer, there was a public member who was present for 3 years, Mr. James McGee. He was president for about 3 years. So this board has seen public members be chair or president. I'm sorry. So in my experience, so.
Thank you, Ms. Marks, for that. And
oh yeah, okay. Yeah, that's before my time.
And Ms. Marks, thank you very much for that. And one last comment that I would like to say, if you could indulge me on that. And I do think whoever also is vice president, I think that, I feel like prior to me becoming vice president, I think 3 years ago, the vice president and the president almost had a meeting, like an executive committee. And so they met, in preparation of the meeting. And I think that while each of the committee chairs get contacted to prepare for the meeting, I think that that's not a violation of the Open Meeting Act for the two of them to come together. And I would hope that our leadership would do that, because I don't think it happened as much. It happened a couple of times. I know Dr. Erickson and I did it a few times, and so did Dr. Phillips and I. But I think that should be the apparatus whatever I'm trying to say. Modus operandi. The modus was not coming first, but it should be the culture of our board that happens, and not necessarily suggesting that the vice president then becomes a president, but I do think that there should be not just one leader. We have two leaders that should be a part of crafting the agenda and being more integral, a part of how we operate as a board. And again, I think 3 years is a long time. That's 3 years of a 4-year term. I do think that somebody else could serve in this role, and I would hope that someone else would.
So with that said, if you would like to accept Ms. Akwe-Badu's suggestion of asking who might be interested, or if someone wants to make a nomination for president, you can do that as well.
We're talking about this president at this point?
Yes.
That was, I think, make it a little less confusing to go office by office.
I think
Dr. Kasuga.
Are there any other nominations?
I wish to nominate Dr. Phillips.
And I would like to nominate Seiran Fu.
Okay, so we do need to record each vote. So I think what would be
and I don't think that you need to do an aye or nay. I think we can just go through and have the vote be for each of those nominees.
Can I would like to withdraw my nomination just for personal reasons, and I appreciate the nomination, but for personal reasons, I'm withdrawing from.
Okay, you do not wish to accept the nomination. Okay, thank you.
Yeah, thank you.
And I'm very grateful for Vice President Jones' nomination, but I too wish to withdraw as well. But thank you.
And then I would say, no offense, Dr. Phillips, I do think that it's important to have another. I feel like the number of years. I would wonder if Dr. Horn, if you'd be interested. I feel like just to change up the leadership. You're not interested. Okay.
Okay. Are there any other nominations for the office of president? Okay. So we'll take a vote for. There's been a nomination for Dr. Stephen Phillips for president, and this would be for the remainder of the 2018 calendar year, correct? Okay. And so, can we have a vote?
Akwebudu. Dr. Phillips.
Bernal, I'm sorry, Kasuga,
Dr. Phillips.
Erickson,
Dr. Phillips.
Fu,
Dr. Phillips.
Horn,
Dr. Phillips.
Jones,
Aye.
Phillips.
Aye.
So the board has elected Dr. Phillips for the office of president for the remainder of calendar year 2018. Okay, and now we move to the office of vice president. So if you would like to indicate your interest, or we can also accept, nominations for the office of vice president.
I nominate Dr. I'm sorry, I just jumped in. Dr. Kasuga for vice president.
I nominate Seiran Fu for vice president.
I nominate Alita Bernal.
I nominate. I guess I want to keep it a public and a licensed member. I will support that nomination of Alita Bernal.
Okay, so did I catch both, Mr. Fu and Ms. Bernal? Did I catch both of those?
Dr. Kasuga.
Oh, okay.
I'm again withdrawing my nomination for vice president for same reasons, but I appreciate it. Thank you.
You don't wish to be nominated, and if elected, you will not serve. Okay. Okay. Different conversation. Okay.
So I have a question, but that's slightly problematic because we don't know if Miss Bernal will accept. Correct?
That is true.
Because of course we've not talked to anybody, correct, outside this meeting. So we would not know if she would want to serve.
Well,
could we postpone that part of the election to the May meeting?
You can do a couple of different things. You can postpone that office until the May meeting, and if so, I would suggest that you then have another election or vote on who will maintain that seat up until the next meeting, like we did from November until now. Or you could do the. I'm sorry. And then, or you could see how the vote goes, and if it were to be Ms. Bernal, you can still put this item on the next agenda, just in case she decides that she does not want to serve. And I would suggest that if you do that, and if she were the one to be selected, then you might want to do in the alternative, if she were to say, I don't want to accept that, have the alternative person carry through till the next meeting,
to act until you can vote again. Does that make sense?
So you're saying vote, so I understand what you're saying. You're saying vote on these two nominees. If Ms. Bernal was to take the majority, then we would hold off until we knew she was going to accept, and in the interim, perhaps Ms. Jones would continue as vice president?
I would say yes to an alternative motion, if she were the one selected, to have a person serve until the next election if she were to indicate, I am not interested. And then you would have that put on the next agenda.
Okay.
Does that make sense?
Yeah.
I'd be willing to do that. I feel like that I think it's hard. I feel that it would be hard to do a vote within her absence because we can't see her face if she's really excited or bummed out about it. So I feel like that would be important to be able to determine her interest. That's what I'm suggesting.
Well, I was just going to suggest, I mean, if you can have a consensus about that, about waiting, if that's what you want to do. You can vote about waiting until the next meeting. Well, actually, if you want to wait, then there needs to be a vote to say, for example, have Ms. Jones continue in the office until the next meeting.
That was my
so that you know you have somebody in the stead of Dr. Phillips, if necessary.
I think my preference would be to take the vote now, personally, but I'm willing to do whatever the majority of the board would like to do.
But since she's not here,
I think if we only had one candidate and she was not here, it would make sense to put it off, but we have two people.
I would move that we move this item to the next meeting, so that Vice President Jones can continue in her role until the further election. Is that what was one of the options? Was that, Lucille, is that what you mentioned?
Yes, that is an option. If you do that, then I would have a vote be taken for either an interim or the continuation of Ms. Jones in the chair in the seat of Vice President to be act as president in case Dr. Phillips is not available between now and the next meeting. You do need somebody who can take the place of the president.
Is that the consensus?
And I believe at the November meeting, the vote was to continue this officers till this meeting, and so that's why we would need a vote on to continue that chair if you want to wait on the election.
And Ms. Marks, that was the reason we continued, so that everyone would be able to have a vote anyway. And that was the rationale for us to continue as opposed to doing it in San Diego because several folks were not there.
So you made the motion.
So move?
So, well, we have the two nominations. What I'm hearing is you would like to, before you vote on that, have a motion to wait until the next meeting to vote on the office of Vice President and to have Ms. Jones continue as Vice President in that role until the next meeting. Is that correct?
That's correct, yes.
Well, that's an interesting question.
You could answer it at the next meeting. You could answer it at the next meeting.
Well, because what you're doing is putting off the vote on those nominations, right? So I think then the nominations would be closed at this point unless the board votes to open them up at the next meeting. But I think what you're doing is saying we want to wait for the vote until the next meeting on the office of Vice President.
Yes. But if there's an inclination for anybody else to make a nomination, then I don't think we should preclude it right now. I mean,
Right now, no. But what I'm thinking is potentially at the next meeting. If I would say right now the nominations are closed. I think that's where we were. Yes, you can. I thought I thought we had asked if there were any additional nominations. I thought I had asked if there were any additional any additional nominations. It doesn't mean that at the next board meeting you couldn't vote to reopen for nominations. So I think then perhaps that is the most clear way of proceeding, which is to say at this point the nominations are closed, because I did ask if there were additional nominations. If the board wishes, and what I've understood you to be continuing was the vote on those nominations. So if the board wishes at the next meeting, if it's on the agenda, well, it will be on the agenda, is to say, is there a motion to reopen for nominations for that? Does that make sense to everybody?
Yeah.
You think that's the appropriate way to proceed?
Yeah.
Okay. So then there was a motion to delay the vote on these nominations until the next meeting, and to continue Ms. Jones in the office of Vice President until that next meeting. Is that correct? Okay, that's the motion. Yes, we do, please.
Want me to go?
And is there a vote? Oh, I'm sorry. I'm sorry. I'm used to Dr. Phillips doing this. Public comment. Board comment. Okay.
Equivadu?
Yes.
Kasuga?
Aye.
Erickson?
Yes.
Fu?
Aye.
Horn?
Aye.
Jones?
Aye.
Phillips?
Aye.
Motion passes.
Congratulations to both of you.
And Ms. Marks, thanks you so much for explaining that, because that has been a very challenging thing, and I think that we haven't, there could have been challenges with abiding by that. And I also just feel like on the record, I think that whoever gets voted in on May should really be able to look at that with the executive officer about executive committee, so that person is actually a little bit more involved in what happens.
Move to adjourn.